For my lordship, not to mention a matter not where for the change of the name of the arbitrator, your lordship, but appointed Mr. Shayak Ranjan Ganguly.
Yes.
Not as an arbitrator, not he not had some conflict, not which is communicated. Not he represents not only the petitioner in some other proceedings, but has also appeared, Lord, sorry, he is appearing against the petitioner in some other proceedings, and also acted for the respondent in some proceedings. Some Lord, he's conflicted both ways. So, Lord, if it could appear as to mention only the name of the arbitrator, Lord, maybe. It's at the last page. Mr. Shayak Ranjan Ganguly, not he. The name is at page, last line of page 12.
Yes.
My lord, I appeared on behalf of the petitioner in this matter, my lord.
Yes.
My lord, may I also indicate another correction, my lord? The name of the respondent has perhaps gone down incorrectly. It should have been spelled UGRO instead of URGO, my lord.
My lord, Mr. Rituban Sarkar had appeared for the respondent also. Not
So give me the name of any other lawyer. Who do you want? Both of you are here. Give me the name. Give me anybody's name. It's enough.
Yes, sir. Mr. Ishan Shah, my lord.
Yes, madam.
My lord, we have no objection.
Ishan Shah.
Mr. Jishu Shah, sir.
Ishan SAHA, right?
ISHAAN SAH.
ISHAAN
SAH.
And what is the number? Do you have the number?
That is one number.
The difficulty is that if I make the correction here, there's not really a correction.
Not it should appear as to mention, but I think then the records will be there. Otherwise, not it will be difficult.
No, the change of the arbitrator, this would actually lead to it's not just a correction. Fundamental change in the judgment.
Change of the personnel of the arbitrator.
That's right.
Because not he's not.
That's right. So since it's already been there, why don't you just move an application before him? I think he'll recuse himself. Probably then we can appoint somebody else.
So, we get a letter from him, Lord, at least in his section 12 disclosure, Lord, also he can say that.
That's right.
Very good. We'll do that and come back. I think, Lord, what your lordship is saying, Lord, will
that will be better.
Yes, Lord, we'll come back with that and then.
Yeah.
My lord, would the correction be reflected in the order as to the name of the respondent, my lord?
Just Priya. And one of it. But then we'll keep, no, not today. Then we'll keep it after. You mention it. Mention.
Grateful, my lord.
May I have your lordship's leave to mention a matter? Lordship, there are few execution applications, your lordship, running in the monthly list of your lordship. If lordship, there are similar matters. If these matters can be brought up to your lordship's list on Thursday, lordship, it will not take much time. 10-15 matters are similar matters, your lordship. It will just go down. Lordship, I'll categorically mention the item numbers of your lordship's list, monthly list.
Let it come in the due course.
Lordship, it's actually pending since a long time. So if that can be.
Let it come in the due course. We'll see.
Oblige, your lordship.
One minute, I'm appearing on behalf of award holder. On last occasion, we have mentioned this matter. I am only one praying, my lord, the warrant should be discharged against the respondent number 3. We not want to proceed against the respondent number 2, Sneha V. Bhaskar. That's what we have mentioned it, my lord.
That's a female.
Not female, my lord. What happened is his name is here, but my lord, somehow
But why
during
have you
the
is it? It's here on mentioning, right?
yes, my lord, this has been mentioned matter.
What?
For my lord, deletion of the name of the respondent number 3 from the record, my lord, and stay of the warrant against the respondent number 3. That's why we have mentioned this matter. We are taking a step for deletion of the name from the education proceedings, my lord, respondent number 3. But in the meantime, warrant is there, my lord. We want the stay of the warrant, my lord. He has not been arrested till date. In him, and we have find out that
Are you asking for deletion of the name of respondent
no,
number
3, my lord, and stay of the warrant. With the warrant is pending against 2 and 3
Have you-
both.
All right, take down. Learned counsel for the petitioner states that they will be that the respondent number or the
3, my lord. Can you, my lord, record the name
Judgment that-
Sneha V. Bhaskar, my lord.
award data number 3,
Snehal V. Bhaskar.
Snehal B. Bhaskar, will be dropped from the array of parties. Full stop. Praise for dropping of award data number 3, Snehal B. Bhaskar from the array of parties. Full stop. Necessary steps shall be taken by the petitioner. Warrant of arrest issued against the award data number 3. In view of the set, the warrant of arrest issued against respondent number 3 shall be stayed. Let this matter be listed the date after polling.
Yes, grateful now. Grateful.
Lordship, I appear on behalf of the award holder. Lordship, here the only thing is the appearance has gone down wrong, your Lordship. Is the correct?
Just give the corrected necessary correction be carried out. Formal order.
Oblige, your Lordship.
My lord, the matter is appearing at my instance, my lord. I am for the award dater.
Yes.
My lord, during pendency of the 34 application, my lord, I have paid the entire awarded amount with interest by account pay check, and the check is encashed in favor of the award holder on 19th of December. Yes, my lord, I am for only submitting, my lord. Let the decree for satisfaction of decree be recorded.
My lord,
And
there was no execution filed, my lord. There was only a section 34 and a section 36(2) application that were filed. My lord, there is nothing that
So
remains.
you withdraw that.
My lord, if that
I
may
am
be withdrawn,
withdrawing section 34, my lord. At least one line be recorded that the entire awarded sum is paid.
Two items, 3 and 4. Learned counsel for the petitioner seeks to withdraw the present petition in view of the fact that the entire awarded amount stands paid by the petitioner. Full stop. In view of the said settlement, the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. That's two. 3. Taken. 3 is 34, right?
My lord,
Yes.
3 is 34, my lord. APCOM
842, yes, my lord.
842 is 34
Item 4.
application.
This is the 36-2 application.
Yes.
Since the petitioner.
That had been stayed, my lord. There was an order that stayed this the operation of the award. That would be of 5th December, my lord. But subsequent to that, the payment was made.
Stay. The petition was already disposed of at the time when.
My lord, the application under section 36(2) has been.
Yes.
Yes.
So nothing survives.
No, my lord.
The other one. So why is it listed? APCOM 894. This is APCOM 894, right?
Yes, my lord.
This was already disposed of. It's already
My
the
lord,
application.
894 is 36 application.
36.
Your lordship directed us to make payment
Deposit the
Yes.
amount.
42 lakhs 5,000 to deposit security amount.
Correct.
But instead of depositing the security amount, my lord, I have paid the entire decretal dues. So 36 is already disposed of.
36 is already.
Item number 4 is already disposed of. Only 34 was pending.
Correct.
Yes, my lord.
My lord, let that be treated as withdrawn and dismissed.
36. It is noted that the APCOM 894 of 2025 has already been disposed of on 7 by this court by order dated so and so 5th December 2025. No further order is required. The same already stands disposed of. Then why did you mention 4? 4 shouldn't have been listed today.
Perhaps wrongly
My
applied.
lord, your lordship's direction was that the order for satisfaction of the decree.
Only 3 should have been listed.
Lordship.
There was no need for 4 to be listed. Since it's listed, then I have to
Yes, my lord.
pass a one-line order. उसमें 4 में से वही करना. No further order is required since the matter already stands disposed of. 894. Yes. Correct.
Lordship.
Wait a minute.
Number 5.
Your Lordship, this is my application. It's appearing in my instance for restoration of the Section 9 application.
Take down. This is an application by this is an application seeking restoration of the present petition, which was dismissed for default on 4/11/2025. Full stop. For the reasons stated in the application, comma, the same is allowed, comma, and the present petition is restored to its original position. Full stop. Consequently, comma, the present petition stands allowed. Yes, main. What is the main petition?
Your Lordship, the reason I have enumerated in pages 3
I
and
have already said
yes, Your Lordship.
the reasons stated. Now come to the merit of the matter.
Your Lordship, the Section 9, Your Lordship, I must be candid, Your Lordship, I am not briefed in the section. I am being led by a senior. Your Lordship, that's the embargo that I'm facing. Today, it was just for moving the restoration application. Lordship will just, because Your Lordship will kindly appreciate, this is a changed brief. That is one of the reasons that I've enumerated in my restoration
Not
application
maintainable.
also. No, Your Lordship, I absolutely bow
Section
down.
9 is not maintainable. You know it very well.
No, Your Lordship, that I
You are
bow down.
seeking relief against a person who's not a
Party to the
party to
arbitration
the-
clause, but
that's
Your
why you
Lordship,
don't want-
perhaps, Your Lordship,
list
chloro
after next
controls
week.
and then sap waters,
the week
Your Lordship will come.
list on. Keep a date. I don't want to keep it pending.
Your Lordship, any day as per Your
Next
Lordship.
week.
Your Lordship, the affidavit of service for this application.
Affidavit of service taken on record. You know there's nothing in the petition.
Your Lordship, that probably I'll take an attempt to persuade Your Lordship.
How can you rope in somebody who's not a signatory to the
Your Lordship, possibly on the point of alter ego, I possibly
No
can,
alter ego.
subject to correction from your
Arbitration Act is very clear.
Lordship.
Not a party, not a party.
Lordship, I'll
You
come
can't
back.
make wife a party and seek relief.
Grateful to you.
You shouldn't have filed a restoration also.
The list of dates. Lord, this is section 29A application. Lordship would recall Mr. Sen, my Lord, had
Yes, he was
appeared
there
yesterday. Lord, it's my petition. Here, my Lord, we had proceeded under
I-
section 9
That's right.
before the.
So after the judgment which has been passed, this is
I
maintained.
accept your Lordship's judgment, where, my Lord, we lost. And therefore, this is the court to come with section 29A.
Mr. Sen had indicated that he will inform the other side. Yes, serve them.
Yes, yes. Affidavit of service filed.
Appeared on one date.
No, no.
They did appear.
No.
They appeared in what time for filing an affidavit? There he's appearing.
Oh, my learned friend is there. He's
You're
appeared.
there. Yes. Mr. Mandal. He's appearing.
Yes, yes. He's also there in the arbitration.
He is muted.
He's
My Lord,
Yes.
audible to your Lordship.
Yes, Mr. Mandal.
My Lord, am I audible to your Lordship?
Yes, you're audible. I think you have no
Yes,
objection.
your Lordship. My Lord, on the last occasion, yes, your Lordship, on the last occasion, my Lord, it was adjourned because there has been an order, my Lord. There has been a judgment, my Lord, which is pending, my Lord, to be delivered by the Honorable Supreme Court on this issue.
No, there's no point.
That is what has fallen from your Lordship on this occasion when
We'll
it was
allow this
adjourned.
application.
My Lord, we do
The
not wish
Supreme
to
Court has
file any
taken few
opposition, my
calls.
Lord. I leave it very well.
Yes.
So we'll allow
Very
this
well, very well.
application.
Your Lordship, my Lord, kindly passes an order.
Go on.
Yes, my Lord. Kindly gives, my Lord, a requisite time, my Lord, so that, my Lord, because the evidence is going on, your Lordship.
Yes, whatever time has been sought. Take down. The
Lord,
present application has been
last
filed.
witness.
The petition under section 29A of the Arbitration and Conciliation Act. Section 29A of the Arbitration and Conciliation Act
My
seeking
Lord,
of the mandate of the arbitral tribunal for completion of the arbitral proceedings and publication of the award. Full stop. Learned counsel, learned senior counsel states that this court-wide order dated. When was the arbitrator appointed?
My Lord,
2nd May 2023.
2nd May 2023.
Court-wide order dated 2nd of May 2023, appointed the
No,
sole arbitrator
we
to
agreed.
adjudicate the dispute between the parties.
Okay.
Full stop. After the expiry of the mandate of the arbitral tribunal, the parties with mutual consent extended the mandate of the arbitral tribunal till 23/8/2025. Full stop. Now the matter, learned senior counsel, Mr. Chaudhary states that the matter is at the stage of
My Lord, completion of, my Lord,
Completion
recording of evidence.
completion
one
of
witness
recording
left.
of evidence. Full stop. You want a 1-year extension. What have you sought for?
1 year, my Lord. I think
Upon
actually we don't
consideration of
need 1
materials
year.
on record,
6
learned
months.
counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the submissions and the material based on record, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the arbitral proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is hereby extended for a period of 1 year from today. Full stop. The learned arbitrator is requested to make all endeavors to complete the arbitral proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, the present petition stands disposed of.
Grateful.
Your Lordship, in this matter, I appear on behalf of the petition. This is the third time the application was filed for seeking an extension of arbitration mandate, Your Lordship. As per Your Lordship last order, I have served the Section 29A application directly to the party. Affidavit service, this affidavit service going to be affirmed, Your Lordship. It's not affirmed, but tracking reports and the postal receipts are there, Your Lordship. It has been delivered. Affirmed. It get it affirmed. I filed it by today itself. Your
Are
Lordship.
they appearing before the arbitrator?
Before the arbitrator, they are appearing. The learned advocate also appearing, and they
You
are
have to
also giving.
affirm it. You affirm it?
Yes, Your Lordship.
Not today.
Item number 8, my lord, I am for the respondent.
My learned friend, my lord, is
I am praying for a short pass for because Mr. Lakhmani is leading me in this matter.
very well. He's supporting me. Now, my lord, here the difficulty is not, my lord, with my learned friend. They are agreeable. We are both landowners in the arbitration. Respondent number 1. You're for the liquidator. Oh, then my learned friend is right. Liquidator, my lord, respondent number 1, my lord, went into CIRP. And my lord, arbitration continued. The resolution professional filed an application in
Mr.
the
Lakhmani had a very interesting argument yesterday. He had argued that in every 29A, when the court is extending the mandate of the arbitrator, then there should be a substitution.
Oh, no, my lord. If the application is filed after the mandate expires.
That issue of application being filed after the mandate is over now.
in every matter there has to be a substitution.
Mandatory substitution. That's
There are other things I can tell your lordship about him.
Either Mr. Lakhmani is appearing too much on the criminal side, or
He's also been a very talented vocalist.
he
A
was
good
singing the
cricketer.
wrong tune for sure here.
Very, very good cricketer. Well, I shall, whenever I get the opportunity, tell your lordship more about Mr. Lakhmani. He's the last in line, my lord, in Mr. Mitra's chambers. So, Mr. Anirban, Ray, me, and Mr. Sharvapriya Mukherjee will not have a field day with Mr. Lakhmani.
That's what happens to the younger one. Yes.
My lord,
May I just make one request, my
Adi
lord?
Bogbina.
My lord, this has been served upon us last night. My lord, the liquidator now, my lord, is in charge of the company. My lord, kindly, my lord, allow me to take instructions, my lord. At least, my lord,
My lord, may I request for Monday, my lord, in that case, next Monday?
Not today.
no difficulty on the Monday.
But if the liquidator has taken control, then
My lord, arbitration can continue. This was the entire argument, my lord, before the learned arbitrator. In CIRP, liquidator, my lord, the resolution professional files, my lord, for stay, and also, my lord, files for a declaration that the termination of the development agreement is illegal, null and void. Termination of development agreement is prior to CIRP. What had happened, my lord, is the developer, my lord, had entered into a development agreement, then done nothing for 6 or 7 years. Landowners terminated, filed Section 9 to protect possession. Thereafter, my lord, company went
but
in.
what happens before the arbitrator, since the CIRP has
So, my lord, now it's gone. Liquidation, this can't be part of the, and they're not even in possession. I am in possession. Section 9 order is one security guard is allowed entry in one room in the house. That's not settled possession. Agreement terminated before Justice Indira Banerjee. My argument was twofold. Number one, you have asked for, as resolution professional, a declaration that the termination is wrong. So therefore, you have requested the arbitral tribunal to rule on the merits of the matter, which is permissible. I could not proceed against you, but you have proceeded. So therefore, on his counterclaim, the question of validity of the termination can be decided. And Millard, we argued the matter on his counterclaim, not on my claims. I have given up my entire claim for damages, all 200 crores. So I just want a decision that the termination, which is pre-CIRP, is valid. And nobody is questioning it. In any case, now that matter is in liquidation, they can't Millard do anything. Company Millard has to be sold in specie. And there's nothing to sell over here. So this is the whole thing.
I take instructions.
And arbitrations concluded. Award is awaited. In the meantime, time expired. I'll request for Millard 1 or 2 months extension to give Millard, the learned arbitrator, time to deliver award.
The time is expiring on 12th of January.
That's Millard, a convoluted calculation which I have made, which may not be correct because I filed statement of claim. They did nothing. Period of almost a year went by. Then they filed this counterclaim.
That's what I saw.
Yes, so I'm calculating it from that counterclaim. But that counterclaim is filed 6 months after Millard entering into reference. So I don't want to take a chance on that alone. That's what I've written in the application. Your Lordship is right.
That's what I read.
But Millard, I don't want a situation where later they say that I filed my counterclaim after a year.
All right, we'll have it on the 13th.
Next Tuesday.
Next
Great.
30. Great.
This is my application of section 29A for extension of mandate of the Millard arbitrator. This is a matter where Millard, your Lordship has already heard an application under section 14.
The only thing is, my lord, they have asked for a extension time period of extension for a period of 12 months, my lord. I leave it before your lordship because it's in the proceedings at the stage where the cross-examination of one of the witnesses of the respondent is going to be verged. It's going to be completed by the next date, my lord.
But as far as Millard, the respondent is Millard concerned, Millard, they Millard were supposed to Millard produce one more witness as they have Millard, they have
I'll leave it to
indicated.
your lordship so far as the time.
So, Millard, maybe a extension of Millard 6 months or 8 months Millard to that effect, Millard.
Arbitrator appointed?
Millard, arbitrator appointed on Millard 18th of December 2023.
First extension?
Millard, this is the first extension. The 6 months extension was done on Millard 12th of July, Millard 2024, which Millard expires on Millard 12th of January 2026. Oh, I'm sorry, Millard 2025, 12th of July 2025, not 2024.
12th of July.
12th of July 2025.
The first extension.
Millard, the 6 months extension, the mutual extension,
Which expires on?
Which expires on Millard 12th of Millard January 2026.
How many sittings?
23
sittings. The last minutes is at page 73 of the petition, my lord.
All right, take down. The petitioner has preferred the present application under section 29A of the Arbitration and Conciliation Act, seeking extension of the mandate of the arbitral tribunal for completion of the arbitral proceedings and publication of the award. Full stop. This court, by order dated 18/12/2023, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 12/6/2024. Full stop. Thereafter, with the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months, till 12/1/2026. Full stop. Learned counsel for the petitioner states that there has already been 23 sittings and the matter is at the stage of cross-examination of respondent's witness.
Yes.
Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the materials on record, this court is satisfied that there has been no delay attributable to the sole arbitrator in conducting the arbitral proceedings. Full stop. In having regard to the advanced stage of the proceedings and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of
But 8 months, my lord, to be on
8
the.
months from today. Full stop. The learned sole arbitrator is requested to make all endeavors to complete the arbitral proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, comma, the present petition stands disposed of.
I'm grateful.
Your Lordship, I'm appearing on behalf of the petitioner, my lord. This is an application for extension of the mandate of the Learned Arbitral Tribunal. My lord, this is the second application before this honorable court for extension. My lord, last extension was granted on the 1st of May 2025 for a period of 8 months. My lord, that
8 months.
for a period of 8 months that was expired on 31st December 2025.
Expired on?
Expired on 31st December 2025. The application was nevertheless filed prior to the date of extension, coming to an end. So, my lord, we are here praying for an extension, my lord. It's at the stage of final arguments. My lord, we are seeking an extension, my lord. 6 months also will do, my lord. The arbitral tribunal probably will be able to pass its final award.
Arbitrator appointed on 1st of May.
1st of January 2023. 5th January 2023 is the date of appointment.
5th Jan.
The first sitting was held on 30th January 2023.
The first extension.
The extension by the parties.
First mutual
Yes,
extension
Your
is
Lordship. It was extended with effect from 8th October 2024. 8th October 2024. That was for a period of 6 months, which expired on 8th April 2025. Thereafter, my lord, the application was filed, the first application for extension.
Yes.
Order was passed on 1st May 2025. My lord, the order is at page 12 of the application. No, I'm so sorry, my lord, the order is at page 10 of the application. It was for a period of 8 months from the date of communication. Communication was made to the arbitrator on the same day, 1st May itself.
All right. And this expires on 31st
December 2025.
Take down. This is an application filed by the petition under section 29A of the Arbitration and Conciliation Act seeking extension of the mandate of the arbitral tribunal for completion of the arbitral proceedings and publication of the award. This court, by order dated 5/1/2023, appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 9/10/2023. Thereafter, with the consent of the parties, the time period was extended till 8/4/2025. 8/4/2025. Subsequently, by order dated 1/5/2025, this court extended the mandate of the arbitral tribunal for a period of 8 months. Full stop. The said time period expired on 31/12/2025. Full stop. Learned counsel for the petitioner states that the arbitral tribunal has conducted more than how many hearings?
44 sittings have been held.
44 sittings. And the matter is at the stage of final argument. Final argument?
Yes,
at the stage of final argument. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. upon consideration of the materials on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the proceeding. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of
My lord,
3 months.
as my lord, at least my lord, I believe 4 months should be enough. My lord, it's final arguments, my lord. My lord,
Final argument is almost over.
my lord,
For a period of 6 months. Period of 6 months from today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavor to conclude the arbitral proceedings and publish the award within the extended time period. With the aforesaid observation, the present petition stands disposed of.
my lord, the next application is also
Similar.
same. My lord, same arbitrator,
Another same
same
the same parties.
Dates, give the dates.
Yes, my lord. My lord, the date of appointment is the same, 5th January 2023. The pleadings were completed on 8th September 2023. 6 months by consent of parties was given, my lord, and that period expired on 7th March 2025. Then we filed the application, your lordship. The application was allowed, the first application on the same date, that is on 1st May 2025. It's at page 11 of the application. It was also for a period of 8 months, which expired on 31st December 2025.
Take down.
It's a similar stage, my lord. The arbitration is also at the same
First
stage of
paragraph,
final arguments.
and see this court wide order dated 5/1, right? The same date appointment is
Appointment is of the same date, your lordship, 5th January 2023.
wide order dated 5th January 2023 appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on.
Sorry, my lord.
Pleadings were completed
Pleadings
on
on 8/9/2023.
Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months.
Yes.
Up to
7th
6 months
March.
would be 7th of
7th March
2025. Full stop. Thereafter, by order dated, this was extended for.
It was extended for 8 months.
Thereafter, by order dated 1/5/2025, the mandate of the arbitral tribunal was further extended for a period of 8 months. Full stop. Learned counsel for the petitioner states that there has been more than
64 sittings here, my lord, in this reference.
and the matter is at the stage of
Final arguments.
Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Having regard to the upon consideration of materials on record, this court is satisfied that there has been no delay, undue or unwarranted delay on part of the learned sole arbitrator in conducting the proceedings. Full stop. Having regard to the advanced stage of the proceeding and in the interest of justice, the mandate of the arbitral tribunal is extended further for a period of.
My lord, similar, my lord, it's the same issues also. Similar issues
From
involved.
today. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to complete the arbitral proceedings and publish the award within the extended time period. Full stop. With the aforesaid observation, the petition stands disposed of.
Item number 12, it's my application under 29A for extension of the mandate. Lordship, this is the second extension that we are seeking. The matter has a somewhat checkered history. On 2 separate occasions from applications under Section 17 orders, it has gone up to Supreme Court on 2 separate occasions. A forensic audit had been ordered sometime last year. The forensic audit is concluded now. So this would require some more time. Accordingly, I was praying for 1 year's extension, Your Lordship. And this is the second extension. The first extension order is at page 55.
Page 50?
55. And the extension, Your Lordship, the mandate, according to our calculations, expired on 8th of October 2025.
Yes.
So I was praying for extension with effect from 8th of October.
So the first extension is 8th of October.
8th of October
For a period of 1 year.
1 year.
Arbitrator was appointed on
7 December 2021.
7 December,
7 December
2021. The first 6 months extension expired
12th September 2024.
12th,
I'm sorry, 12th March 2024.
12th March 2024.
2020.
12th March.
4. There was an interim order passed.
Interim award was passed.
Interim award on
Interim award was passed.
17th April 2023.
Yes.
interim award.
Yes, interim order, interim measure.
No, that's the. I think my lord is inquiring about the interim award or the order. The award.
Interim award.
That is 17th April 2023, Your Lordship.
Interim award is in 17th April 2020. No. My lord, I'm sorry.
17th April, huh?
My lord, 8th March 2024 was the interim award. That's at page 47. 8th March 2024 was the interim award.
Yes, that's what I'm asking.
Yes. 8th March 2024.
Interim award.
20th April is the order, interim order of under section 7.
Yes. 31-6 interim award.
Yes.
That was on what my
8th
learned
March.
friend said. The interim order under section 17 was
All right.
17th April 2023.
And the auditor was appointed on
Auditor was appointed, Your Lordship, on
Sometime around that time, actually, my lord. Right now, I can hand over the last minutes. I can hand over a soft copy. It's been fixed, my lord, on 6th February 2026 for hearing.
22nd March
Yes.
2024.
22nd March.
22nd March 2024, actually.
And the report has been filed. Hearing on that report is fixed in February 2026.
Yes, 22nd March 2024, 53, page number 53. That was the direction passed in the 25th sitting.
22nd. Right. Take down. The petitioner has preferred the present petition under section 29A of the Arbitration and Conciliation Act 1996, seeking extension of the mandate of the arbitral tribunal for completion of the arbitral proceedings and publication of the award. Full stop. This court-wide order dated 7/12/2021 appointed a sole arbitrator to adjudicate the dispute between the parties. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months up to 12/3/2024. Full stop. During the subsistence of the mandate, the arbitral tribunal passed an interim award dated 8/3, right? 8/3/2020. Full stop. Thereafter, by order dated 22/3/2024, the arbitral tribunal appointed an expert auditor to conduct a fresh audit of the financial statements of respondent number 1 for the financial year 2019-20 to 22-23, with a direction to submit the audit report before the arbitral tribunal. The said audit report has been completed and the same has been submitted, right?
Yes.
The same has been submitted before the arbitral tribunal. Learned counsel for the petitioner state that the when was the first extension? There was an extension, right?
Extension by the court.
8th October 2024 at
This
page
court, by
55.
order dated 8th October 2024, had granted an extension of 1 year to the arbitral tribunal. Full stop. It is further stated by the learned counsel for the petitioner that several hearings have already been. How many sittings?
36. Last sitting was
Stated that
36.
36 sittings have been conducted by the arbitral tribunal. He states that further proceedings can be effectively taken only after the submission of the audit report.
That's already been submitted. Manoj. The audit
been
report has been
submitted.
submitted. Now hearing on that audit report is fixed. We've applied for
further
another
states
award.
that the hearing on the audit report is to be conducted before the arbitral tribunal. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Having regard to the upon consideration of materials on record, this court is satisfied that there has been no undue or unwarranted delay on part of the learned sole arbitrator in conducting the arbitral proceeding. Full stop. Having regard to the advanced stage of the arbitral proceedings and in the interest of justice, the mandate of the arbitral tribunal is further extended for a period of
1 year, Your Lordship.
1 year.
With effect from 8th October, Your Lordship will kindly
With
mention.
effect from 8th October 2025.
2025.
2025. Full stop. The learned sole arbitrator is requested to make all reasonable endeavors to complete the arbitral proceeding and publish the award within the extended time period. Full stop. With the opposite observation, the present petition stands disposed of.
Obliged.
Anything else?
Deeply obliged. Nothing.
Obliged.
Deeply obliged.
The matter where, my lord, my neck is on the guillotine.
Oh, yes.
I have avoided it twice. My lord, the slice, my lord, chopping it up. Last time, my lord, out of desperation, I requested, my lord, your lordship for a not today, so that, my lord, I could take instructions as to whether I will create a fixed deposit in my name. My lord, we sat with the client. My lord, he tried to convince me that he has the best case. So, my lord, I don't have that instruction. Now, I felt, my lord, that one document I did not correctly point out to your lordship, which may be the cause of your lordship, my lord, forming an opinion against me. There may be other causes also, my lord, on the facts. But maybe if I had, my lord, explained that document correctly, your lordship may not, my lord, want to pass an order. May I, my lord, just have 2 minutes and not more than that?
Your client seems to have a lot of ego regarding.
No, not ego, my lord, not ego. He told me very simply that this is a person who has supplied me, and he's right, my lord, when he told me this. My lord, I have no ego. He told me that this is a person who has supplied me with defective goods. He also told me that you have gone to court and you have said that, because now recordings are there, my lord, 20% odd is defective. But the fact of the matter is 80% is defective as per that document. So you must request and correct the situation. If after that I lose, I will lose. But you please explain the document.
He will lose only before the arbitrator. Here it's only about.
No, my lord, but fact is, may I just take 2 minutes now? My lord, kindly have a look at.
He has a, as you already say, that he has a robust financial health.
Very robust.
Very robust.
But
So
he
what
is,
the
my lord,
difficulty?
upset with the fact that somebody
It
gives
is
me
upset.
back.
That's the right word.
Yes. Somebody gives me wrong goods. Then he goes and attaches my bank account.
He can win before the arbitrator. What's the big deal? We are not deciding his dispute. We are not holding him guilty.
No, no.
He's only protecting him to the extent of that small little.
No, no, I understand.
Sum of money.
No, no, absolutely. I understand. But my lord, kindly only just a review on 3 points. 5 consignments of 2 lakhs each. First is 31st May 24. Last is 29th. Lord, 31st May 24. 19th June 24. 21st June 24. 26th June 24 and 29th June 24. The 5 dates of the invoices, all under one purchase order. On testing, the contract and SOP both have to be read together. There is, my lord, a procedure for, my lord, inspection and reinspection by us in the contract, but SOP, which your lordship, my lord, pointed out, says that it is joint inspection. That, my lord, is at page 46. My lord, K is what your lordship was on, and absolutely, my lord, I humbly, my lord, agree that if the SOP says joint inspection, then in that case, it is something which must be, my lord, given precedence over the contract, which says my inspection alone.
Correct.
Now, thereafter, my lord, if your lordship, just one page I want to show of the same SOP, page 49. These are, my lord, the specifications. And this is where, my lord, we have, my lord, failed to indicate the correct facts to your lordship. Page 49, last paragraph.
Yes.
My lord, these are the parameters. One, my lord, is the drop impact strength of the cement bag. So, my lord, the tensile strength has to be such that when you load it and you do the drop impact test, it must be perfect, which is why second column your lordship will see no failure. Last, my lord. So on drop impact test, there can be no failure at all. There are, my lord, numerous other parameters. So this is, my lord, the situation. Now, my lord, in respect of the second consignment, page 77 is the report. My lord, I had indicated, and for a change, my lord, correctly, that the whole 2 lakh, my lord, consignment is defective. Your lordship was pleased to accept it and say that, well, that is only 20%. My lord, last line is, hence this lot is rejected. That's 20%. Then, my lord, after page 7, this is 25th of June 24. And your lordship was also right that after 25th of June 24, on 26th June and on 29th June, you accepted more goods. Then, my lord, is the important document not correctly explained by me, which is, my lord, 11th July 24. After, my lord, all consignments are over, my lord, please take page 78 once. Here, my lord, first mistake which, my lord, we had committed, my lord, I had committed, is not to explain that, to fail to explain, my lord, that this is in respect of 3 invoices. So 6 lakh bags. So 2 lakhs gone. This is 6 lakhs. Now, my lord, please come to remarks and observations. We had stressed on number 3.
Yes.
That out of 6 lakh bags, 1240 damage, 958 rejected, 1432 mouth open found. And your lordship was pleased to appreciate this and said that very well, it's only 22-23%. So then why will you hold back payment? You've paid 50 plus, why will you hold back payment? What, my lord, we had omitted to indicate is number 2. My lord, please see this. 1 and 2. Breaking strength width-wise poor quality found not matching, which has an impact on 2. Drop impact test not found satisfactory, which has the effect of rejection of the entire 6 lakhs. So drop, Miller, I showed your lordship page 47 of SOP, that no tolerance, no failure. My lord, please just once more, my lord, look at page 47. At page 49, last of the parameter, drop impact strength, no failure. None of the sac shall fail in drop impact strength test. drop impact test should be done as per BIS norms, except that drop impact test will not be done for any edges. So when drop impact fails, 6 lakhs go. So my lord, it is over, the rejection is 80% because of this. Now, please once more, my lord, come back to page
Mr. Chaudhary,
78.
before the rejection, you should have followed the due process.
Of my lord, but he accepts he cannot question the rejection because page 78, which is what I wanted to, my lord, show your lordship. We, my lord, in his handwriting, he says, we such and such ensure that the quality of bag will be improved from our next supply. He accepts and he says, further requesting you to kindly consume the rest balance quantity. So he accepts this and he says, I'll do better, which is why the last 2 lakhs was not, my lord, tested, consumed, etc. Now, only the last one sentence. What happens if there is an 80% rejection and I have consumed the goods? Do I have to pay 100%? Is the question I ask myself. For that, my lord, the contract is relevant. My lord, please see page 47. M. When a lot or a consignment or bales is rejected, but ACL is compelled to use the same because of low inventory level, bags can be accepted by ACL at 50% of the price of bags. So, my lord, if I, my lord, accept rejection worthy bags, in that case, I have to pay 50% as per the contract. Now, I have paid over 50%. 88 lakhs 78,288, which is approximately, my lord, it will be, I think, around 55%. Over 50% is the admitted. So, in terms of the contract, to, my lord, summarize, 80% rejected, accepted by him in his own handwriting, and he's asked me to use, and I have paid him 50% in terms of the contract. So according to me, he's not, this is 61% consideration paid. Now this crucial fact, my lord, that number 1 and 2 being different from number 3 at page 78 was not explained by us, my lord.
Yes.
This is the situation, and my lord, I am open to, my lord, criticism. I am open to admitting the fact that over the last 2 days, we should have explained this. Maybe, my lord, there's a chance that your lordship would consider it differently. My lord, these are my humble submissions. We'll accept, my lord, whatever your lordship indicates. We'll also request my learned friend to agree to, my lord, an arbitrator so that matter can be resolved at the earliest.
My claims would be around
Not running
55
away.
lakhs odd.
Yes.
So any junior member of the parliament, that's my only thing. Because the schedule 4 would be very less. So
You agree to anybody of your opinion who will do it quickly and in a proper way, we'll accept that.
No, but our counter claim will be much more than 50,000.
don't have, you said you've adjusted.
That's fine. That's fine. So, bolo, you name. I'll agree. And we'll
So
go.
if that is the case, then why should I decide the section 9?
No, section 9 kindly secures that. This is why this is the last throw at the dice.
No,
So I'm not agreeing right now.
We'll agree.
So I'll not agree right now. I'll file a section 11. So let us contest my section.
May I have my lord's leave?
After he leaves, I'll agree.
I'll pass an order because this will take time.
But 2-3 things, if
yes, please.
My lord, the clause which my learned senior had shown,
Yeah.
learned senior friend had shown, does not kick in. Because your lordship would kindly have a look at page 41. My lord, the emphasis given today was drop impact test. Kindly sees serial number 7 at clause number 7 at page 41. Here, my lord, a detailed procedure for drop impact test has been given.
Yeah.
Now, there's a box within. Now, the respondent was trying to think out of the box, but kindly sees the language here, the acceptance criteria. In case sample fails in drop test, the lot shall be kept aside for joint inspection. Never done. Basis the result of joint inspection, decision shall be binding on both the parties. Never done. True. Then the second one. In case any lot passes the plant inspection, however, during running on the packing floor, frequent burstage of damages are observed, the lot shall be kept aside for re-inspection at plant QC lab and drop test. Not done. So, they on a unilateral premise that it has failed in drop test will not do. The contract speaks otherwise.
One, Mulad, from the box Mulad submission, Mulad, this page 78, which was shown by my learned senior friend, Mulad, my senior, Mulad, page 78 is Mulad.
Only joint inspection.
It was the joint inspection.
And
They have already Mulad participated.
Just a minute. What he's saying is entirely different from your understanding. That is the only joint inspection which has been done is on 11th of July 2024, wherein you had pointed out 3 deficiencies which are there. One of the deficiency which is there is the drop impact test, and the drop impact test, if there is any dispute regarding that, that has to be solved by a joint inspection. Further, no joint inspection has been taken. So the ground that the drop impact test, they have failed in that is not correct. That is not correct. If any of the bags which had failed in the joint inspection, in the drop impact test, there should have been a further joint inspection. That joint inspection only to the extent of deciding that these are the 3 categories on which you are rejecting the goods. Further, no action has been taken, and that's exactly what he's pointing out.
And the issue of payment of 80% is also not there.
Perhaps, Mulad, I can Mulad add an issue here. If your lordship kindly takes page 77, which was Mulad the first Mulad inspection done Mulad by Mulad Amrit Cement, which is Mulad the respondent.
Only one inspection has been done.
It was Mulad found that Mulad there was Mulad this breakage was also Mulad found there. Breaking strength widthwise very poor quality found. So when Mulad 2 lakh was Mulad found to be Mulad not as per Mulad the mark, Mulad then only Mulad kindly takes now page 76. Page 76 by an email of 27th of June 2024, we invite them for joint inspection. And then Mulad joint inspection was done at Mulad page 78. So Mulad, it's not the case that Mulad from the first inspection only, after finding out that the drop impact test has failed, Mulad, then only Mulad, the joint inspection had been not been carried out. So first inspection done by Amrit Cement, asked them to please depute your personnel, joint inspection done, finally conducted on 11th of July, and Mulad found that the entire lot is gone.
What else?
Page 76, 77 is a unilateral document.
I got the point.
After that is superseded by 78.
What else?
Nothing else. And it's not the case that the rejection is of 80%. The final rejection is page 79. That is 0.53%. There is no other joint inspection where there is any rejection. Only joint inspection
is of 11th of July. That's the only joint.
Nothing else.
Any facts? I'll dictate later. So heard reserved. We'll get it by tomorrow.
I'm so grateful.
Grateful.
Yesterday, the respondent, yesterday, one adjournment was taken in this matter. The facts remains, the
petitioner herein the borrower. Now, my lord, he entered into an agreement with the finance company, my lord, the respondents, and they have extended, my lord, the finance to purchase a truck. Now, my lord, the period, my lord, the agreement entered into 2023 March. Now, it is not yet, my lord, expired or no termination notice has been issued. During the pendencies of this, my lord, on October 2025, my lord, the respondent company repossessed the assets. My lord, that is a vehicle. Now, my lord, repossessed the assets.
What is the status right now?
Now, my lord, kind
Just one
but the
second,
next
just-
page,
Just
my lord.
one second. What is
My lord, the
status?
possession is with us, my lord. They were defaulting. That's why, in terms of the agreement, we repossess them. My lord. Right now,
You have
we
not
are
sold it?
no, no, my lord. We are agreeable to return the asset as soon as they pay the amount, my lord. There's 4 to
Yes,
5
my lord,
installments.
that has been
4 to
stated in
5
my petition.
installments are.
Yes, that
My lord, if they
installment,
pay, we'll return the asset.
let them specify the amount of installment which has been due. And I agree, and I
Let
agree
them
to pay.
approach. Let them approach the
Yes,
company.
that
my
has
lord,
been
and they will
approached. Your lordship kindly come to that is after, my lord, after they take over there, my lord, your lordship kindly see the page. Page 14 is there later after repossessing. Then, my lord, we wrote them on 12th of November. That is at page 16. That we are agreeable to pay the whatever be the dues in respect of that particular agreement, the defaulted amount with the installments. So we are agreeable. But that has been written herein. So that has not been answered yet. Let them say whatever be the dues, I will pay. Let them, as because they have not taken, they have not sold it.
No, no, no.
So they have not sold. Let it be. I will pay. But this is only prayer subject to the payment of the installments.
Yes.
Yes, my lord. My lord, as they are agreeable to pay, my lord, they can approach us, my lord. Whatever the amount that is due, if they pay, we'll return the asset, my lord.
Make the payment.
My lord, I am agreeable to pay. My lord, that's why, my lord, I have written them. Your lordship kindly see that I have written. Let them specify whatever be the amount in installment is due.
2 weeks.
Yes, my lord. Let them approach, and thereafter, otherwise, I'll take
My lord,
instruction and bring
my
the
lord.
amount, whatever amount is due and
Keep
payable.
it after 2 weeks. In the
My
meantime, you don't sell the
No, 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 my lord.
vehicle.
Much obliged.
Then I
With
want
us, my lord.
Well, let it be kept because 2 weeks. In the meantime, I will pay because 2 weeks is very well time. My lord, that before that I will pay. But let them stay for third party right is creating. Let them stay on
the
that.
petitioner has preferred the present petition under Section 9 of the Arbitration and Conciliation Act 1996, seeking a direction upon the respondent to hand over the possession of the repossessed vehicle bearing registration number WB 29C 3312 and further seeking an order restraining the respondent from transferring, selling, alienating, or otherwise creating or otherwise disposing of the said vehicle. Full stop. It is the case of the petitioner that for the purpose of purchasing the aforesaid vehicle, the petitioner availed a loan of rupees 43 lakhs 4,200 from the respondent. Under the loan agreement, the petitioner was required to repay the said loan in 58 installments of rupees 93,430 each, commencing from 1/6/2023, comma, with the tenure of the loan extending till 1/3/2028. The petitioner asserts that he had been regularly paying the EMI till July 2025 and thereafter defaulted in the repayment. Full stop. It is further alleged that the respondent on 17/10/2025 repossessed the vehicle without any prior intimation or notice. Full stop. The respondent states that there's an outstanding amount. Do you have any
That
amount?
I have to take
The
instruction.
learned counsel for the respondent states that the vehicle is in their possession and the same has not been sold. Full stop. Learned counsel for the respondent further states that the petitioner has defaulted in the payment and thus the vehicle has been repossessed by the respondent. This court has heard the argument as advanced by the learned counsel for the parties and has perused the materials on record. Full stop. It is not in dispute that the petitioner had availed the loan facility from the respondent, and under the loan agreement, the petitioner was supposed to repay the loan by way of was supposed to repay the loan by way of making monthly installment payments till this is till 2028, right?
Right.
Till 2028. Full stop. Learned counsel for the respondent states that if the petitioner makes the entire payment, the state vehicle can be handed over to the petitioner. He further assures this court that the vehicle will not be sold and that the petitioner can approach the respondent for the settlement of the debt. Full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. In view of the statement made by the learned counsel for the respondent, the respondent shall remain bound by the statement made before this court and shall not sell the vehicle for a period of 6 weeks, sell or create any third party interest for a period of 6 weeks, unless this matter after 4 weeks.
One indulgence, so far as the amount which is payable, that should be the installments amount.
Go before him.
Fine.
Much up.
Well, 15, my lord, I am for the respondent, my lord.
Lordship, I appear on behalf of the petitioner.
My lord, before proceeding with the, this is a section 9 application, my lord. Before proceeding with the section, my lord, I have something to say. My lord, the advocate on record who is conducting this matter, my lord, he has engaged me in the morning. My lord, if my lord will allow me some time to let me get
Not
ready.
today.
My lord, kindly give me at least, yes,
Tuesday.
lord. I'm grateful.
Not today.
Not today, Your Lordship.
Yes, yes. I'm grateful.
Oblige, Your Lordship. Lordship 16, I appear on behalf of the petitioner. Lordship, the case here is that Lordship, on 31st May 2024, an agreement was executed between the petitioner and the respondent for purchasing a vehicle, Your Lordship. The particulars of the vehicle, Your Lordship, is at page number 3, paragraph 5, Your Lordship. Lordship, it was to the loan was sanctioned to the tune of 31 lakhs. Subsequent to that, Your Lordship, they have defaulted and we had duly terminated their agreement, which is at page 24 of the petition. Lordship, the postal receipt to that effect is at page 25. Lordship, the only apprehension is that the vehicle is with them. Lordship, I'll apprise Your Lordship on another point. Lordship, please kindly comes to page 9 of the application, paragraph 27.
Page 9.
Page 9 of the application, Your Lordship. Paragraph 27. Lordship, they had filed a title suit. Despite having knowledge that the agreement has an arbitration clause, they filed a title suit before the Learned Civil Court. Lordship, we have duly contested it with filing our defense, which is section 5 and 8. Lordship, it is pending for hearing. In the meanwhile, Your Lordship, we have an apprehension that the vehicle will be sold. A third party interest will be created on the vehicle. Your Lordship, we have duly served them the affidavit of service to that effect, Your Lordship. Notice of motion to Lordship, the notice of motion is also. Lordship, we are praying for receiver over the vehicle, so the vehicle is secured.
The petitioner has preferred the present application under Section 9 of the Arbitration and Conciliation Act 1996, seeking appointment of a receiver to take possession of the hypotheticated vehicle bearing page, where's the vehicle detail?
Lordship, the vehicle details are at page 3, the Lordship, paragraph 5.
AL 4825 bearing registration number WB23F 6388. 6388. And further seeking an order restraining the respondent from disposing of the said vehicle or creating any encumbrance or otherwise dealing with the said vehicle. Full stop. It is the case of the petition that the respondent had availed a credit loan of rupees
31 lakhs, Your Lordship.
31 lakhs.
It's at page 3, Your Lordship, paragraph 4.
31 lakhs from the petitioner for the purchase of the above mentioned vehicle by agreement dated, what is the date of the agreement?
31st May 2024 it is at page 3, Your Lordship, the first line.
By loan agreement dated 31st May 2024. Full stop. The said vehicle was hypotheticated to the petitioner.
Lordship.
Full stop. The respondent, it is the case of the petitioner that the respondent defaulted in making the repayment of the said installment as indicated in the loan agreement dated the date of the 31st May 2024. Full stop. Learned counsel for the petitioner submits that the respondent have failed to make the monthly installment payment since.
Lordship, as per the termination notice, Lordship, they had made 2 payments and we had an outstanding of 29,46,950.
Since when the installment? First install, how many installments?
Lordship, first few installments they paid, maybe 2 to 3 installments because the due is considerably 29 lakhs.
The learned counsel for the respondent states that the petitioner owes an amount of rupees.
Lordship, as per the termination letter, 29,46,950. And Lordship, as per our calculation in the petition, Your Lordship, it's 29,96,950.
29,96,950. That's in D, prayer D.
Lordship, prayer D.
Full stop. The petitioner further states that the loan agreement was signed within the territorial jurisdiction of this court.
Lordship.
Full stop. He states that the loan agreement, that in terms of the arbitration clause in the loan agreement, this court has jurisdiction to entertain the present petition. Full stop. This court is the competent court to entertain the present petition. Full stop. This court has heard the arguments advanced by the learned counsel for the petitioner and has examined the documents on record. Full stop. After examining the record of the present case, this court is satisfied that the petitioner has established a prima facie case for the grant of the interim protection. Full stop. The existence of the loan transaction and the subsisting hypothecation over the subject vehicle, prima facie demonstrate that the petitioner has an enforceable right.
Lordship.
Full stop. The balance of convenience also lies in favor of the petitioner, as the vehicle continues to as the vehicle constitutes the secured asset, and the petitioner has anticipation that the same will be dissipated and that the interest of the petitioner will be frustrated. Full stop. Refusal of the interim protection would expose the petitioner to irreparable loss and injury, inasmuch as in alienation or encumbrance of the hypothecated vehicle would render the petitioner's claim nugatory, resulting in harm to the petitioner, which cannot be compensated at a later stage. Full stop. In view thereof, this court grants the interim protection to the petitioner by appointing, give a name of, we'll give, there's a list of receiver, by appointing so-and-so as receiver as paid forthwith to take possession of the hypothetical vehicle AL 4825 bearing registration number WB23F388 and to keep the same in the safe custody subject to order of this court. The receiver is entitled to payment of such and such in addition to the additional expenses incurred by the receiver. Full stop. The respondent is restrained from alienating, encumbering or otherwise dealing with the aforesaid vehicle in any manner whatsoever. Full stop. The officer in charge of the concerned police station shall render all necessary assistance to the receiver for the due implementation of the order passed by this court. Full stop. The receiver shall take possession of the said vehicle and submit a report before this court within a period of how much time? 4 weeks, 6 weeks?
Lordship, 4 weeks.
4 weeks. Within a period of 4 weeks. List on, give after 4 weeks.
Oblige, Your Lordship.
my lord, I appear for the petition. But section 9 application, my lord, it's really, my lord, I'm seeking a, my lord, ex parte order at this stage, very limited order. I'll ask for, my lord, further orders at a later stage. I'll just give your lordship the background very briefly, my lord. Not the petitioner before your lordship
So you have
belongs.
not served the other side.
No, I'm moving ex parte. Not very limited order I'll seek, which can't prejudice the other side. Not the background is this. Not the petitioner before your lordship belong to the SRAG group of companies. Not your lordship may know because of various matters before your lordship. Not the RBI proceeded against not these companies, and not the application was filed under the RBI Act and also under the Insolvency Code, not by which an administrator was appointed. Not ultimately a resolution plan was framed by the NCLT, not under which these companies were taken out of the fold of the Kanoria's and it was taken over by a company called NARCL, National Asset Reconstruction Company, which is owned by again a consortium of nationalized banks. So these companies were taken over. Now these companies were taken over. When they were taken over, attempts were made by the administrator and the new shareholders now to recover their dues. So this is one of those. Now in this case, transaction is very simple. Now there's a loan agreement. 525 crores was to be disbursed as per their needs. 477 crores was disbursed. In terms of the agreement, the loan was to be repaid in 8 years. The loan was given in 2018, repayment in 2026, the principal. But they were to keep servicing interest. They did not pay the interest. A default notice was given. I'll show your lordship those documents. A default notice was given. They did not pay the interest part. So we went to NCLT and filed a Section 7 application for recovery only of that interest amount.
Serve them, Mr. Bachawat.
Just give me one moment. There's nothing to it. There's actually nothing to it. Now, so we went to NCLT for recovery of only the interest. That has not yet been admitted. So, in the meantime, the principal amount, because of default of interest, we recalled the entire principal amount. So, I will go to arbitration on account of this principal amount and the interest. Now, under that agreement, there are various securities. One of the securities is all receivables of the respondent. Now, one of the receivables of the respondent, is a loan given to a Sterling group of companies, which are not the Sunday Saras. It was all over the newspapers. They had defaulted to all banks. Ultimately, that matter, arising out of criminal proceedings and other things, reached the Supreme Court. In Supreme Court, a representation was made by the promoters of those companies that we will pay 5,000 odd crores against dues of all the lenders. Supreme Court accepted that and directed these amounts to be paid to various banks for disbursement to all the lenders. So now that amount has been deposited pursuant to Supreme Court orders and it is going to be paid out to all the lenders. So one of these receivables which are secured to me is this amount which will come to the respondent. And it's not a large amount, it's somewhere in the region of 500 crores odd, which is going to come in. My dues today are in excess of 900 crores. But all that I'm saying is, when they receive this money, let them not deal with this money or create any charge for the time being. I'm not asking for anything, but I will ask for injunction against their bank accounts in their presence. But for the time being, if a disbursement is made by UCO Bank, this money will be out of hand. This is charged to me. That's all I need to show your lordship. There's an agreement.
But there will be more people who must be sitting in.
This is exclusive charge to us. I'll show that. I'll show that too. And this particular amount, but I just need to show your lordship that. The loan agreement starts at page 38. If your lordship turns to page 45 first. There your lordship will find the amount.
So what is the difficulty in serving them?
If I serve them and in the meantime if there is no injunction, this money will be gone. This is pledged to me under the agreement very clearly. There can't be a dispute and it's not acknowledged by them in the balance sheet. I'll take your lordship straight to that. If your lordship please comes to the securities, hypothecation of all receivables.
2018 agreement, right?
My lord, I'm sorry.
The 2018 agreement.
Yes.
45.
Yes, my lord. I'll skip the amount, so they're not necessary. Let me just show your lordship, not the hypothecation. If your lordship sees the deed of hypothecation not executed, not which will be at page 155. Page 155.
155.
150. I'll take your lordship straight to the deed of hypothecation. The deed of hypothecation is mentioned in the loan agreement itself, that there will be a separate deed of hypothecation, which is there. Now, my lord, if your lordship sees the deed of hypothecation, it starts not at page 155.
Yes.
And if your lordship would come to the schedule of that straight away, not which is at page 173. The pledged assets include, now please see capital A, all receivables of the hypothecated, including flows from the project. So, my lord, all receivables are charged over here. And, my lord, if your lordship then, my lord, please turns, my lord, the page and comes right to the, my lord, last para at page 174. The assets mentioned in A above shall be charged on exclusive charge basis. So, my lord, this is exclusive charge to me. Now, my lord, there were defaults. The notices are, my lord, annexed. My lord, if your lordship wants to see, my lord, those default notices, my lord, page 385 is one notice, my lord, where default in interest. I don't think your lordship need to be concerned with that as of now. But your lordship will find only the interest is claimed. When they don't pay, we go to IBC. And, my lord, when they don't, my lord, when the matter is pending because of, my lord, failure to service interest, we recall the entire loan. So that's what this is for. Now, my lord, the recall notice in this case is page 409. And your lordship will find that the amount due, if your lordship sees page 410, is 912 crores. If your lordship will turn to, it starts at page 409. If your lordship comes to page 410 at para 6. So the principal and interest is not 912 crores. So this has become my claim. Now, my lord, I'll show your lordship the acknowledgement in their balance sheets. If your lordship please comes back, my lord, to page 398. Page 398.
Yes.
Forms part of their balance sheet. If your lordship comes to, my lord, item number 4 at page 398.
Long-term borrowing.
Long-term borrowing, my lord, your lordship will find term loans from financial institutions, 28 structured quarterly installments after moratorium of 8 years. This is referring to my loan because my loan is exactly that. And, my lord, your lordship will find this is exactly not. We had disbursed 477 crores. For some reason, they have not acknowledged 447 crores. 447 crores is acknowledged. And it's there in the balance sheet for the next year also. That also I'll show your lordship. That is not at page 501. So my loans are acknowledged. And your lordship will find in both of them, when your lordship sees page 501, long-term borrowings, just under that, your lordship will find a asterisk saying nature of security, secured by way of first charge on movable, immovable assets, both present and future, charge on cash flows from borrower in the form acceptable to SEFL, which is, and pledge of 100% equity shares. So, my lord, this is linked clearly to us. Now, the urgency is this. Lord, there is a Supreme Court order passed on 19th of November 2025. Lord, it starts at page 456. And Lord, the relevant portion, your lordship will find at page 464. So, Lord, the Sunday Saras or the Sterling Group made an offer to pay 5,000 crores odd. And if your lordship comes to para 9, or Lord, if your lordship goes to the para just above para 9, Lord, where there is a para 8, small para 8, at this stage, learned senior counsel Mr. Rohatgi appearing submits that to get rid of all proceedings and to put a quietus to the litigation of criminal cases with regard to CBI, ED attachments, etc., he shall deposit the entire amount of 5,100 crores. So, my lord, this deposit is made, my lord, and the Supreme Court says that if they deposit, then my lord, all these proceedings will go. And my lord, directions are given to that effect. That order is not the minor modifications made from time to time, after which, my lord, the representative of these groups, my lord, write to us. My lord, please takes, my lord, page 478. My lord, sorry, the letter starts at 477, saying that they have deposited this amount and it is to be paid. My lord, please see, my lord, the portion at page 478. Just one portion I'll show your lordship. My lord. Your lordship will find, my lord, the third para, not beginning with SGORPL and ABSWL, we are not concerned with that. The next one, SEZ.
I'll come back and find. Yes. So the first is your loan agreement.
Yes.
Of 2018.
My lord.
Right. The second is the hypothecation.
Yes,
which
my lord.
is
Hypothecation of receivable.
receivable. This is the 12/12/2025, right?
Yes, my lord.
Then you have the balance sheet.
Yes, my lord. The balance sheets acknowledging my dues.
Acknowledging your due.
Then, my lord, I show your lordship that he is to get some money and that money is now to be paid and received by him. This is what I was showing your lordship. My lord, if
Page
you'll-
501.
Yes, my lord. Page 5, my lord, page 477.
47.
Page 477.
Yes.
And if your lordship would turn to page 478, the representative of that Sterling group is saying that money is being paid to you. And if your lordship would see the third para, but with the heading SEZ,
Yes.
the lordship will find a figure 973 crores,
Yes.
bracket 1014.17, all lenders outstanding 76 crores already paid, UCO Bank Calcutta for distribution to the consortium banks and Aviral Maritime Cereal Group. So, my lord, this money is to be paid by them partly to, my lord, the respondent.
Partly to the respondent.
Yes, because it's to be given to other lenders also. So I'm not asking for blocking all of it. Whatever comes into the respondent, I say he should not charge it or pay it to anyone else. That's what I'll be asking for. Now later I will ask for orders against their bank accounts and for giving particulars. But to the extent money is paid by UCO Bank, not to the money to the extent UCO Bank pays them any money, that should not be dealt with. This is what I'll be asking for. Now, there's in addition, there's just one other thing which I need to show your lordship. But this company is in very bad financial situation, which is why I'm not apprehension. If your lordship would not please go back to the balance sheets, which I had showed your lordship, and comes to page 498. Now at 498, your lordship will find the income for the year 2024 is not close to nothing. It's 12 lakhs odd. But in addition, your lordship will find they are showing expenses of about 25 crores a year, and the profit after tax is a loss, minus 25 crores. So it's loss making, it's got no earnings. Not if this money comes in and it's charged to someone else or not disbursed to someone else, I cannot get hold of it. So, this is it. I'm asking only for limited protection that if money is paid by UCO Bank, it is charged to me, being a receivable which is hypothecated to me, that should not be dealt with in any way or manner, which I am entitled to in any case.
And what are the Supreme Court?
Yes, I'll show your lordship. But I'll just give your lordship the background. We are not really concerned with it, but the fact is money is coming. So there was a Sterling group of companies. Now, the Sterling group of companies had taken loans from a large number of people. And there were a number of proceedings initiated, including before IBC, criminal proceedings by various lenders and all of that. So, the promoters were about to be arrested, so they moved the Supreme Court. And they said, look, we are willing to pay 5,000 odd crores if you stop the proceedings against us. So, they deposited 5,000 odd crores pursuant to Supreme Court orders, which is to be used to pay off lenders. So, one of these lenders is the respondent now. So that money is to now come in, it's a return from that Sterling group to them. It's a repayment of the loan or a receivable which is hypothecated to me.
Yes, what else?
This is all that there is to it. Is Section 9. At the moment, I'm not seeking any kind of final relief. I'm not seeking any punitive order against their assets saying don't operate their bank accounts. I've asked for those prayers. I will. For the time being, if your lordship would only consider prayer A, which is at page 19. But this money, if they receive it, should not be used or dealt with in any way or manner. which he can't, not the negative covenant, it's hypothecated in my favor. I have a right to stop this money. What we are saying really is not money received pursuant to the settlement in the Supreme Court, which is being disbursed to lenders. Not that part has now been received by UCO Bank. Now UCO Bank is going to disburse it to all the lenders, including him. So if he receives anything, that should not be dealt with in any way.
Yes.
But fully covered under the reliefs of Section 9. There's one little legal problem. I'll point this out to your lordship. But it may be contended that, look, I have filed a proceeding under Section 7 of the IBC, which is pending before the NCLT. But it's now well settled. That does not come in the way of arbitration or Section 9 proceedings. The judgments of first of the Bombay High Court and now settled by the Supreme Court. Till admission of the petition, it does not become a proceeding in rem. Therefore, there is no bar to arbitration. I have the judgments. If your lordship wants, I can. But I'm pointing out this is a point that may be taken by the other side. This is the one thing. The other thing is this amount which is to come in from the Sterling Group. It was originally a loan given by me to the Sterling Group. Thereafter, they took assignment of it, and this has become their loan and a receivable which is now charged to me.
So initially the loan was?
But the loan to the Sterling Group,
yes,
there were a large number of companies. Some loans had been given by me to some of those companies. The respondent took assignment of those loans. So, against consideration, they took the right to obtain that money. When they obtain the right to take that money, they have charged it and hypothecated it in my favor. These are the two things that the other side could say. That's what I'm pointing it out. But at this stage, therefore, I'm not asking for any drastic order, of injunction against the bank accounts. I'll pay for that in their presence. But if in the meantime they deal with this money, that's the end of the matter. We will not be able to recover it at all. I've showed your lordship it's a loss-making company. Huge expenses they are showing, but they have no income.
The only thing which you have shown me, Mr.
Yes,
Sawat, is the clauses. You have not shown any of the clauses.
Yes, I'll go back to it. I'll now take your lordship into it in a little detail, if your lordship.
If you want to order, you have to give.
I will. No difficulty there. The loan agreement, if your lordship comes to it at page 30, at page 45, I'll take your lordship to it.
Yes.
But it starts at page 45, and your lordship will find clause 2 at page 45. It says the borrower requires funds for the purpose and has approached the lender to avail of 525 crores loan facility. So, this was to be the loan facility. Now, this was repayable after 8 years. That your lordship will find at page 66. Then, my lord, interest has to be paid. That is, page 61, clause 2.5.1. Let me tell you schedule 1. If your lordship has seen 2.5.1, the borrower shall pay to the lender interest at the rate and in the manner and the dates as mentioned in Schedule 1. Page 61.
Yes. Page 61.
Yes, ma'am.
Clause
2.5.1. The borrower shall pay to the lender interest at the rate and in the manner and on the dates as mentioned in the Schedule 1. Plus spread, if any, etc. Now, this Schedule 1 is at page 126. And your lordship will find that yearly interest is payable. So, while the principal has to be paid at the end of 8 years, interest is payable every year. At 12.5% per annum.
Yes.
Then, of course, there's provision as usual for penal interest and other things. He defaulted in paying interest. I'm not going into that at the moment because I'm taking your lordship through the agreement. Now, thereafter, if your lordship sees the securities, if your lordship turns to page 71,
Yes.
clause 3.1. The heading is Article 3, security. The obligation of the borrower shall be secured by exclusive charge on receivables by way of hypothecation under a deed of hypothecation. And first charge of all movable assets of the borrower, present and future, by way of hypothecation. So, pursuant to this, a deed of hypothecation is executed, which your lordship will find, which I have showed your lordship at page 155. And both of them have the arbitration agreement. Now, if your lordship would then come to page of that pledge agreement, clause 2 at page 156. In pursuance of the loan agreement and for the consideration aforesaid, the hypothecator as the legal and beneficial owner of the said assets and properties mentioned in Schedule 1 hereto does hereby hypothecate the said assets as and by way of charge as detailed in Schedule 1 to the lender as security for the repayment of the loan facility and payment of other monies due, etc. So from here, if your lordship would come straight to that schedule 173, Schedule 1, which I showed your lordship, short particulars of the said assets and nature of shares, nature of charge, capital A, all receivables of the hypothecator, including cash flows from the project. So it's not very broad, all receivables, and that's under the heading capital A. And if your lordship turns the page to page 174 at the bottom, I showed your lordship, the said assets mentioned in A above shall be charged on exclusive charge basis. So, I have a charge on the receivables. And what I'm seeking now is a right to stop him dealing with the receivables which are charged to me. So, this was then, if your lordship sees page 102, which is back to the agreement, what is an event of default?
102.
102. So there's an event of default which has occurred. Clause 8.1.2 at page 102.
Eight point
1.2. Non-payment of interest or other dues. So, non-payment by the borrower of interest or any other money payable by the borrower under the financing documents on days when such amount falling due for payment under the terms of the agreement by way of check or dishonor of check. So, failure to pay interest is a default. Now, there are various other default clauses also. Now, I just need to show your lordship, therefore, that this default took place. So, may I take your lordship first, to the demand notice at page 385. So, this was for default of interest at that stage. 385, which is volume 3. Here, my lord, if your lordship sees the third para, the defaulter has the borrower has defaulted in payment of I'm sorry.
Yes.
So, my lord, if your lordship comes back not to page 385.
Yes.
So, my lord, because they did not pay the interest, we issued a default notice. And if your lordship comes to the third para,
Yes.
the borrower has defaulted in payment obligations under the loan agreement, and an amount aggregating to 37 crores is payable by the borrower on 23rd November 2022 is detailed below. And if your lordship sees the next clause, due to non-compliance of the terms of the loan agreement, including non-payment of dues, we hereby inform the borrower has committed an event of default. Such default in payment of principal and interest is in contravention. As per clause 2.6 of the loan agreement, payment default attracts not penal interest, and then not the last para on that page. We regret to inform that the borrower has failed and neglected to clear the outstanding dues as mentioned above. In view of the above, borrower is hereby requested to make immediate payment of the overdue amount of 37 crores, 34 lakhs, etc. But this is the only the amount of the interest. So, my lord, we make a demand for that. Now, my lord, after this, not they don't pay this. So then we file a section 7 application before the NCLT under the IBC, claiming only this defaulted interest. Not that application is pending; it has not yet been admitted. Now, my lord, because of failure to pay it, we issue a further notice, my lord, which your lordship will find at page 409. Now we recall the entire loan. So this is not issued on 12 December 2025. And if your lordship not turns to the relevant paragraph, para 6 at page 410, the borrower is requested to pay to SCFL forthwith from the date hereof the aforesaid amount of 912 crores. So, Lord, this is the principal and the interest together, which I now claim, Lord. So, Lord, this is the amount which is due. Lord, thereafter I showed your lordship acknowledgement of the principal amount which I have lent. Lord, that acknowledgement, Lord, is at page 398 and 399. And Lord, the second balance sheet, not for the next year, I showed your lordship, not that's page 501. But if your lordship would take the acknowledgement at 501, I just need to show your lordship one other thing. I was placing it not very briefly then.
Yes.
Your lordship has seen not long-term borrowings, which I've showed your lordship. Not that is at 447 crores. Not is admitted over there. That relates to mine. And Lord, I want your lordship, I want to show your lordship not another heading, but other current assets, other non-current assets, not which is item number 7. Could I take your lordship there once, Lord?
Yes.
So they also show that they have granted loan to the Sterling Group. Your lordship has got that?
Yes.
So, Lord, they have given a loan of 404 crores to the Sterling Group, which is this amount which is now, Lord, going to come back pursuant to the Supreme Court order. That Sterling Group had defaulted, not Supreme Court said, pay everyone and we'll let you off scot-free. They've deposited that 5,000 crores. Now this is to be disbursed to all the lenders. So one of the lenders, not to the Sterling Group was them. So not this money, not is also there in their balance sheet. This is what will come back, not, or at least not a part of it, or maybe more. We don't know how much will come in, but not because this is secured under our loan agreements, not and the hypothecation agreements, not. Lord, I was respectfully praying that for the time being, your lordship will grant me this limited protection that if and when the money comes, Lord, it should not be, Lord, used or charged to someone else. There's only one last thing which I need to show your lordship, that there's an arbitration clause, Lord, in these agreements, because I'm in a section 9. That, Lord, your lordship will get at page 115, the arbitration clause. Lord, clause 9.4, Roman 2. In the event of any claim, dispute, or difference arising out of or in connection with this agreement, including but not limited to the existence, validity, performance, interpretation, implementation, or termination of the agreement, or as a consequence of a nullity, or in connection with any breach or alleged breach of This agreement, including an event of default between the parties hereby agree to refer the disputes to arbitration under the provisions of the arbitration agreement. Now, my lord, this arbitration agreement is defined in the agreement earlier at page 46. So the definition at page 46, not if your lordship would please come to that.
Yes.
Please give me a moment, Lord. I've lost it. Yes. At page 46. Lord, arbitration agreement shall mean the arbitration agreement dated 29 June 2018. So, Lord, there is a separate arbitration agreement, which therefore Lord, is also there. Lord, if your lordship would not please take that. Lord, that is at page 138. I'm sorry, Lord, it starts at 142. 142. So this arbitration agreement, no. I'm sorry, I've given a wrong page. 140, 142. Yes, we're at 143, the arbitration agreement. So, it's covered by the separate arbitration agreement as also the arbitration agreement contained in the loan agreement. And there's a jurisdiction clause also, which is Kolkata. So, this is the background on which I'm seeking this limited protection with the right to pay for further interim orders in their presence.
Petitioner has preferred the present application under Section 9 of the Arbitration and Conciliation Act 1996, seeking inter alia an order restraining the respondent from utilizing, encashing, or creating third-party interest in respect of the settlement amount received or to be received by the respondent under the OTS of Sterling SEZ and Infrastructure Limited in its bank account number 917020055180639, opened with Axis Bank Limited, Salt Lake Electronic Complex Branch, or any other bank account operated by the respondents. It is the case of the petitioner that Shri Infrastructure Finance Limited had sanctioned a dispersal, had disbursed a financial facility of 5 crores 25 lakhs.
But if your lordship would permit one correction, not disbursed, that was sanctioned. Disbursed amount is not at para 6, 477.8 crores.
Has sanctioned and loan amount of 525 crores in favor of the respondent for develop, construct and maintain ports of all kinds of logistic services. Ports and all kinds of logistic services. This was for a particular place, or it says
The place called Dahej, Dahej.
So it's particularly for this work that the loan was sanctioned, or anything else?
Whether it would be limited to this, not I'll just check and tell your lordship. It was for this port, but whether this could be, please give me a moment, not I'll just tell your lordship. But it was for this project, not it was for this project perhaps. Not. Because the project is not defined at page 54. Yeah. Not Article 2. Not Article 2 gives the answer. Not. Article 2 at page 59.
Article 2, not really.
But 2.1.8. 2.1.8, borrower shall avail the loan facility for the purpose of the project. And what project is defined, but at page 54 to mean, project shall mean the loan facility shall be availed of for acquiring, taking over all weather port at Dahej in the state of Gujarat.
For a weather multi-cargo port at Dahej in the state of Gujarat. For construction of a weather multi-cargo port at Dahej in the state of Gujarat. Pursuant to the sanction letter dated 29th of June 2018. Full stop. Subsequently, the respondent executed a deed of hypothecation The deed date is?
The deed date is not 21st January 2019. Page 155.
January 2019. Deed of in favor of SIFL, whereby the respondent hypothecated all its assets, including the present and future asset, without limitation, cash flow, receivables, outstanding monies and demands that may become due or accrue during the subsistence of the hypothecation agreement. Full stop. As per Schedule 1 of the loan agreement, as far as the Schedule 1 of the hypothecation agreement, interest on the loan facility was repayable on a monthly basis at the Shri prime lending rate commencing from the first interest payment immediately succeeding the initial disbursement. Full stop. In terms of, that was clause, what is the clause? 8. In terms of clause. In terms of clause 8.1.2.
Yes.
Of Article 8 of the loan agreement, failure to pay interest on the stipulated due date constituted an event of default. Full stop. The respondent committed default by failing to pay interest as per the agreed repayment schedule. Full stop. In the meantime, corporate insolvency proceedings, corporate insolvency resolution process was initiated against Shri by the NCLT Calcutta.
No, it's actually by the RBI, not by the
By,
Reserve Bank of India,
by-
before the
Before wo chhod do. Shri before the NCLT Calcutta. Full stop. Thereafter, what happened there?
not a resolution plan was framed under which two stray companies, SIFL and SEFL, were both not taken over by a company called NARCL.
Wherein a resolution plan was
Sanctioned.
Was sanctioned. Wherein this company, what was it?
This is SEFL, the other one is SIFL.
Wherein SEFL and SIFL, in consonance with the this was transferred to.
They were both taken over by a company called National Asset Reconstruction Company Limited, NARCL.
Whereby both the companies were taken over by National
Asset Reconstruction Company Limited, NARCL.
Full stop. By virtue of the resolution plan and the business transfer agreement, the petitioners issued a demand notice dated 29/11/2022, calling upon the respondent to pay the outstanding interest aggregating to, this is
37 crore, 34 lakhs, 73,126, page 185.
37 crores,
34 lakhs,
34 lakhs, 30, how much? 37?
73,126.
73,176. Within 15 days, full stop. Upon failure of the respondent to comply, the petitioner issued a loan recall notice.
Before that, it initiated proceedings before the NCLT under Section 7 of the
Learned counsel for the petitioner states that the petitioner initiated a Section 7 proceeding before the NCLT Calcutta,
which has not yet been admitted.
which is still pending adjudication. Full stop.
But would your
The
lordship
petitioner
use the word
issued a-
which is pending admission?
Which is pending admission. Full stop. The petitioner issued the loan recall is
Page 409, 12th of December 2025.
issued the loan recall notice dated 12th of December 2025. For an sum of rupees 9 crore 12 lakhs 912632997
not
900 912 912 9, 63, 29, 711. Full stop. Loan recall, no loan recall notice for a sum of rupees. All right. As the respondent failed to discharge the said liability, the petitioner. Full stop. Learned counsel for the petitioner further submits that SIFL, being the holding company, had sanctioned cumulative loan facilities for an aggregate of 335 crores
525.
To Sterling SEZ
No, that's not 520. Had
335 crores.
Yes,
to,
yes.
to Sterling.
I heard 520. I'm sorry.
Sterling SEZ Infrastructure Limited, a company belonging to that Sandeshara Group, right? The company belonging to the Sandeshara Group. Full stop. Under the additionally, SIFL, two companies you have sanctioned loan.
Yes.
SIFL also sanctioned a loan facility of rupees.
Your Lordship will say the stray companies had lent to various Sandeshara companies.
He further states that the said company had lent out money to various other companies belonging to the Sandeshara Group. Full stop.
And these were taken over by the respondent.
And
These
the
were
same
assigned.
the same were taken over by the respondent. Full stop. Learned counsel for the petitioner further states that the Sandeshara Group had approached the Honorable Supreme Court, wherein, which is that order?
The order begins at page, it's order dated 19th November 2025.
In the Honorable Supreme Court, while it's order dated,
starting at page 456.
What is the date of the order?
It's 19th November
19th
2025.
2025. The operative portion was?
The operative portion, if your Lordship comes to para 9 and then para 11. And the reliefs granted are at para 12. And if your Lordship sees para 12 too, the amount to be deposited before the registry of this court on or before the date specified, permitting the petitioner to make deposits in separate tranches shall be kept in short-term fixed bearing deposits.
The para 12.
Then there are minor modifications which have little bearing on our matter.
So we are only concerned with para 12.
To summarize that order, if I could just put it this way, in proceedings before the Supreme Court, the Sandeshara and or the Sterling Group had agreed to make payment to satisfy the claims of all lenders.
The Sandeshara Group, before the Honorable Supreme Court, had agreed to make payments of the dues of all the groups in terms of the quashing of the FIRs which were filed against them. Full stop. Learned counsel for the petitioner states that in terms of the hypothecation agreement and in view of the clause, that is clause 8, right?
Yes.
8.1.2.
8.1.2.
All the receivables were to be paid to the petitioner.
At which a charge to the
charge to be paid to the petitioners in view of the loan agreement as well as the hypothecation agreement. This the petitioner has been able to establish a prima facie case for grant of interim protection. Full stop. The existence of a valid and subsisting loan transaction and the admitted default on part of the respondent and the petitioner's enforceable contractual and proprietary rights over the receivables of the respondent to the receivables of the respondents creates a right on the petitioner and if the same is dispersed, it will cause damage and irreparable loss to the petitioner.
If I could request one more line, then, my lord, in view of its financial difficulties as appearing from the balance sheet.
In view of the financial difficulties appearing from the balance sheet. Full stop. In view of the same, the balance of convenience lies in favor of the petitioner. Accordingly, the respondent is restrained from utilizing, withdrawing, encashing, alienating, or creating any third-party interest in respect of the settlement amounts received or to be received under the said one-time settlement in the bank account specified herein or any other account operated by the respondent for a period of 2 months.
Your lordship can make it shorter period and make it returnable, but that way no one can complain. But your lordship
For a period of 6 weeks. The respondents are permitted to file the affidavit in opposition within a period of I'll make it 4 weeks.
May I put it this way, but the other side is perhaps entitled to come and object before filing affidavits. Normally, on the original side here, we make the matter returnable before directions are given for.
Then I'll make it 4 weeks then, or 3 weeks, and
your lordship makes it 3 weeks, makes the matter returnable, not within 2 weeks or 1 week, whatever.
3 weeks, and for a period of 3 weeks, let this matter be listed next week. Then I'll keep it after a week. Keep it after a week.
Deeply.
Returnable will be next week.
Next week.
For a period of 3 weeks, returnable next week. They'll definitely make a hue and cry.
My lord?
They'll definitely make a hue and cry.
No, that's why I said it's in fairness.
But since the loan agreement and the hypothecation are in your favor and the receivables should go to you, so I'm inclined to grant this.
Deeply.
Only 3 weeks, return. Give a date next.
18. Lordship, I'm appearing for the petitioner in the matter.
Yes.
Lordship, before my learned friend starts, item number 18 to 22 are the similar matters, Lordship. These are under section 36(2) filed by the petitioner. Now, the difficulty is that we have the petitions, we have the numbers of the petitions, but we do not know which registration number belongs to which petition because these have been given separately. The petition which has been shared with us, the scanned copy doesn't bear the registration number. We asked to the learned advocate on record of the petitioner for giving us the registration number. He has given us the registration numbers in a separate mail. But which registration number belongs to which petition, that we do not know.
Lordship, the email was given with the PDF. The PDF was given along with the registration number. We have replied to their mail. And again, we have received another mail this morning for the same.
Yesterday, I did a mail there on. Yeah.
You clarify between yourself. We'll keep it after 2 days.
And Lordship, this 36(2) pertains to the 34 application which is pending, which is running in the monthly list as item number 151 to 155. We have a maintainability point in that 34 application.
We'll see that first. Not today. Keep it day after tomorrow.
Not today.
All of them. 18 to
18 to 22.
All right. Rest of the matters after lunch. Supplement.
My lord, I am on behalf of the award holder in this matter.
Well, also I'm for the judgment dated number 1 and 2.
Yes.
হ্যাঁ ফার্স্ট টাইম আছে।
আমার পরে বলুন। আমি
আমি
এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো,
সত্যি বলবো,
সত্য ছাড়া মিথ্যে বলবো না, কোনো কিছু গোপন করব না।
কোনো কিছু গোপন করব না।
আপনার নাম বলুন।
আমার নাম উমেশ আগরওয়াল। UMESH AGARWAL।
বাবার নাম
রাজকুমার আগরওয়াল।
আপনার বয়স
38 years।
কি করেন?
আমি আয়রন এন্ড স্টিলের বিজনেস আছে।
অ্যাড্রেস
74/1 নারকেলডাঙ্গা মেইন রোড, কলকাতা 54। 74/1
নারকেলডাঙ্গা মেইন রোড,
কলকাতা 54।
When will you make the payment?
Yes sir, I will make the payment but I need some time.
You are appearing?
Yes, sir.
File your affidavit of asset.
Well, also kindly tell him to serve the copy of the application.
We have served them. We'll serve a fresh copy. Lordship, may I be permitted to make a small submission? Lordship, if you could refer to page number 26 of the execution petition. Lordship, the agreement is between the proprietorship firm and the financing company. Lordship, I'm praying a short prayer that may there be direction upon the judgment debtor to disclose the assets and the books of the proprietorship firm as well with the affidavit of assets.
It will all automatically come. He's the proprietor. It has to come.
Okay, Lordship.
Take down.
Thank you, my lord.
আরেকজন আছে।
One more. Okay.
আমি
এই মামলায়
সাক্ষী দিতে এসে যা কিছু বলবো সত্য বলবো, সত্য ছাড়া মিথ্যে বলবো না, কোনো কিছু
গোপন করব না।
নাম বলুন।
অবিনাশ আগরওয়াল। AVINASH।
আগরওয়াল। বাবার নাম
রাজকুমার আগরওয়াল।
এজ
34।
অকুপেশন
Business.
সেম অ্যাড্রেস
Same address.
70/1 নারকেলডাঙ্গা মেইন রোড।
In terms of the order dated 27th November 2025, the award dated number 1 and number 2 have been produced. Both has been administered.
Well, also leave me with file the button.
The award dated number 1 and 2
Many.
states that they'll be filing the affidavit of asset. Undertakes to file the affidavit of asset within a period of 2 weeks. Full stop. They also assure this court that they will remain present for examination or any other purpose as deemed appropriate by the court. Wakalatnama is taken on record. Let this matter be listed for examination. When do you want?
Lordship, 4 weeks.
After 4 weeks. We file it immediately.
Grateful.
Yes. Any Thursday? Give any Thursday. After 4 weeks. This is charged.
Grateful, Lordship.
No, sir.
Well, I'm for the judgment data.
That's why I appear on behalf of the award holder.
এই মামলায় সাক্ষ্য দিতে এসে যা কিছু বলবো সত্য বলবো সত্য ছাড়া মিথ্যা বলবো না কোনো কিছু গোপন করবো না স্বরূপ কারক AREP KARAK RAK গোপাল চন্দ্র কারক 37 ফার্টিলাইজার রয়েছে সোনামুখী বাঁকুড়া নিশ্চিন্দপুর সোনামুখী বাঁকুড়া সোনামুখী বাঁকুড়া
Lordship, I'll make a very small submission with regards to this. Lordship, his total claim as on date, Your Lordship, as stated in the execution application is 19,70,000. They have come to us, they have approached us prior to this. We had offered a meager amount of rupees 1,85,000. They primarily agreed to it, then they backed off. Lordship, we still have that offer on board. If he's willing to pay tomorrow, we'll give the NDC tomorrow only and realize our dues towards that claim.
Copy of the application, my lord, was not served, my lord, priorly.
Forget about the copy of the application. What he's saying, you take instruction to
But I'll take instruction on this. I'll take instruction on this, my lord, and
Lordship, he has himself gone there.
ऑफर किया ना आपको
Lordship, that's
1,85,000 पे खत्म करने के लिए
হ্যাঁ ওরা বলেছিল
करना है
1,80,000 বলেছে
करना है
আপনাকে কি ওটাতে রাজি আছে না
Lordship, a claim of 16 lakh.
আমি বলেছিলাম 1,00,000 দেবো বলেছি
Lordship, he's reducing from that also. Lordship, 16 lakh.
I'll take instruction on this.
take down in terms of the order dated same order 27th November 2025 the award letter number award letter number 1
Just avoiding him.
oath has been administered
It's third in time and again. और एक एविडेंस का भी दुकान पड़ेगा दुकान सब कर चुके पापा ही नहीं मान पाते
right ordering it with a recorded warrant step from the court of law
Whatever, যেগুলো থাকে
that comes with the standard procedure SOP. Oblige, Your Lordship.
Grateful.
Just the resolution of judgment letter, item number 1, received 9 of 2020, Court of Mahindra versus Street Share Category.
कोई प्रॉब्लम नहीं
examination
I solemnly affirm that
in whatever
I will
depose
depose
by way of evidence
in this suit
I shall
speak the truth
and no part of it
shall
be false
and
I shall not
conceal
anything.
anything.
Your name, sir.
Vikas Kumar Gudgutia.
Kumar
Gudgutia.
G
GUTIA. TGUT, no H. Son of late Madhusudan Gudgutia. MS Gudgutia. Age 56.
Occupation.
Business.
Address
P10 Lake Town. Currently is Lake Town. Block B. Second floor. Calcutta 89.
You have to submit your affidavit of assets in this court through your advocate, and the date will be given, and you have to come on that date.
Yeah.
Okay. We undertake to file.
Yes. Number 2.
But we have not received copy of the execution.
Get copy of the execution petition.
Or we undertake to file our vakalatnama in the meanwhile.
File it in the registry. File the affidavit of asset within a period of 2 weeks.
Right.
Partial division. Item number 23.
Yeah, my appeal, Miller, rising out of the order passed by the learned arbitrator, Miller. Section 17, Miller, it's a 37 appeal, Miller. Now, Miller, the order has been passed after, Miller, the expiry of the period for mandate, Miller. That's the only, Miller. That's the main ground I'll press upon, Miller. May I, Miller?
Expiry of the mandate now.
Gone. Miller, it's got so, Miller.
But that is automatically gets extended, isn't it? If they are moving an application.
I know, it's a section 17 order he has passed after the mandate has expired. No one asked us extend. No one has asked for extension. Extension not
Let them
prayed.
appear, we'll see.
Yes, let them appear, Miller. Yes. Lordship may admit I'll serve and come back on Monday. This is the short point, Miller. And I'll file, Miller, the statement of claim and the counter statement what they have filed. Keeps it on Monday or Tuesday whenever Lordship's list. That's the only short point, Miller, involved. The other points, but if Lordship is with me on the first point, I need not trouble my Lord with any other point. Because even by participation after that period, Miller, the time doesn't get extended unless you file an application.
Take down the petition has preferred the present appeal under Section 37 of the Arbitration and Conciliation Act 1996, assailing the interim order dated 19th August,
yes.
19th August 2025, passed by the learned sole arbitrator under Section 17 of the Arbitration and Conciliation Act 1996. What is the impunity in the order?
Miller, the impunity in the order, Miller, is that, Miller, there was a development agreement. Under the development agreement, Miller, the entire amount, their space plus amount had already been paid to them. But however, the arbitral tribunal, despite holding the there is no prima facie case, has asked Miller, the respondent, not to, Miller, the last paragraph, not to keep all, Miller, the amounts which will get from the project, Miller, in a separate account. But the prima facie case is not in the favor of the petitioner.
So he has modified the interim order.
Yes. Earlier interim order, but he has held there is no prima facie
Just
case.
read para 13, sir.
Yes. Under this, I am of the view the interest would be subscribed. The interest order is subsisting modified by allowing the party to execute requisite conveyance deed in favor of the purchaser of the flats and the other portions of the area on the condition the respondent shall keep the considered amount of the deed executed in favor of the intended deposit in a separate account, interest-bearing account to be opened and maintained jointly by the advocate on record of the parties, namely such and such in a national until further orders. Now, my Lord, however, such conveyance prior would be required to be given to respondent or his advocate. Now, Lordship will kindly have, Lord, para 11, Lord, and para 12. The prima facie case or para 10 onwards, the prima facie case has been held to be para 10. If your Lordship takes para 10 is directly opposite to para 13.
Read it.
Prima facie, it appears that even without taking into consideration the payments allegedly made or received by the said Yakub Tarabhai Johar, the payments which have been made by the respondent to the claimant exceeds the sum of rupees 1,77 lakhs. In any event, payment of such sum respondent to the claimant would be required to be proved after leading evidence. However, it prima facie appears that the entire payment of security deposit under the agreement has been made by the respondent to the claimant. The claimant is not and cannot be entitled to any protection on account of the same.
In terms of the development agreement dated 9th October 2005, the respondents were required to complete the entire project within 42 months, though it has been alleged by the claimant that construction and or completion of the project was delayed by the respondent, but it is not really in dispute that the project has been completed, and according to the claimant, it has been allocated 43,000 odd of the sellable area, though it is really entitled to an area of 74,000 square feet and odd. It has, however, been sought and contended respondent claimant has been allocated more than 43,000 square feet. As alleged by the claimant, the said agreement is a product of negotiation subsequent agreement between the two entities, and such it is unbelievable that the claimant and or the person in control thereof for long did not keep track of the receivable from the project. However, whether the claimant has been allocated an area of more than 43,000 square feet or not cannot be ascertained without certainty from the documents disclosed in the proceeding, and the same has to be demonstrated ascertained at the final hearing of the arbitration proceedings. This is my counterclaim. Though the claimant has prayed for an order of injunction respondent dealing any part of the property until the allotment of 31,000 square feet in favor of the claimant, there is a subsisting order to that yet in my continuing such order would not be beneficial to the party, as completion of the registration of documents in favor of the intending purchaser, some of whom are already in possession of respective portion, would not inure benefit either of the parties, and same may also lead to penal consequence multiplicity of proceedings. Only if Millard 13 is the order, Millard 10 Millard 13 cannot be a conclusion of 10 and 11 Millard. This is my on merits.
Correct. Take down. By the ensuing order, the learned sole arbitrator modified the subsisting interim arrangement and permitted the parties to execute the requisite conveyance deed in favor of the purchasers and other portion of the project area, subject to the condition that the respondent shall cause the entire consideration payable under such conveyance to be deposited in separate interest-bearing account to be opened and jointly operated by the respective advocate on record of the parties, namely Dvip Raj Basu and Sanjay Genodia, with a nationalized bank to be retained therein until further orders. Learned counsel for the petitioner, learned senior counsel for the petitioner states that the said order itself is contradictory and shall be set aside. He further states that the order has been passed after the expiry of the mandate of the arbitral tribunal, which itself renders the order void.
So submission,
right?
Yes, absolutely.
List the matter for hearing on
any date will not convenient to
the other side has not been served.
No, other side will serve and come.
List on after 4 weeks?
Yes.
After 4 weeks?
Let's sit, Millard, on the second week, there is some Millard. If it goes, Millard, we have to go back again to a fresh arbitration.
Second week.
Second week.
Second week. February.
Also records, Millard, it's my submission, Millard, that there was no application for extension filed by either of the parties.
Learned counsel for the petitioner submits that to the best of his knowledge, no application for extension
of mandate has been
the arbitral tribunal was filed by the
either of the parties. Grateful, much obliged.
Yes.
Ninth. Grateful, much obliged. Yeah, application grateful. Application
24.
May I please, my lord?
Yes. Yes, Mr. Sir.
That's some amount of embarrassment at the moment, because I find, my lord, that the arbitrator whose award is assailed is sitting right behind me. So, my lord, But this is, my lord, trifle embarrassing for other reasons also. Here, my lord, a preliminary question that we will be, my lord, raising before your lordship is, my lord, with regard to, my lord, whether, my lord, the award was, my lord, at all, my lord, within the jurisdiction of the tribunal. In this case, my lord, I'll just give your lordship, my lord, 1 or 2 dates. My lord, this arbitration had been commenced in 2013. Well, the arbitrator who had initially been appointed, Millard, was then elevated as the judge of this High Court, Millard, Justice Arindam Sinha, who's now in the Allahabad High Court. Well, after his lordship's elevation, Millard, Mr. Shamrat Sen was appointed arbitrator by an order of this Honorable Court passed on the 18th of February 2014. Now, Millard, that order is relevant. I'll just hand up a copy of that order to your lordship. Millard, because that order, Millard, recorded amongst other things that, my lord, the arbitration will proceed, my lord, from the stage where the earlier arbitrator had stopped. And, my lord, that no further oral evidence would be adduced. And that is why, my lord, there was an abridgment of the time frame. My lord, one of the questions that will arise for your lordship's consideration is, my lord, when the court had, my lord, fixed a time, whether the parties could have, by their own volition, by, my lord, participating in the proceeding, could have, my lord, extended the time. Because, my lord, now your lordship knows that 29A, my lord, requires that, my lord, arbitrations will have to be completed within a particular time frame.
Right.
My lord, 1 year, then, my lord, 6 months at the consent of the parties, and then, my lord, it is the court's, my lord, discretion in the matter. And now, my lord, we have a judgment of the Supreme Court which says that, my lord, ultimately, if the, my lord, arbitration is not concluded within the 1.5 years period that is available, then, my lord, the original arbitrator will have to be substituted. I do not know, my lord, to what extent that is a good judgment.
I saw that judgment, but
Well, I am a little confused with the judgment because, my lord, that is contrary to, my lord, other judgments of the Supreme Court.
Absolutely.
My lord, however, my lord, what the Supreme Court, my lord, intends to convey is, my lord, that the timelines are, my lord, to be strictly adhered, or at least to an extent, my lord, to be strictly followed. It is impossible to adhere
that
to the
judgment
time.
was cited before me yesterday. For the first time, actually, I had a.
It is, my lord, against, my lord, other judgments of the Supreme Court, and, my lord, quite honestly, my lord, it is not a very practical, my lord, scenario. Well, be that as it may. My lord, Supreme Court judgments, my lord, we now know that even if it's obiter, it is binding. So, my lord, whatever it is, my lord, now, my lord, here, the question that would fall for your lordship's consideration is what would be the effect of, my lord, the court stipulating a timeline within which the reference must be completed. My lord, 29A, my lord, was introduced in 2015. My lord, 29A per se does not govern situations, my lord, before 2015. My lord, the learned arbitrator here was appointed in 2014. Now, my lord, so therefore, my lord, technically speaking, and my lord, if one goes by the Tata Cellular judgment, which I shall show your lordship in some time, technically speaking, my lord, perhaps, my lord, the 1.5 year, my lord, timeline does not apply to arbitrations which have commenced, my lord, before 2015 amendment came into it. But, my lord, that would not ultimately, my lord, do away with the question as to, my lord, what would be the effect of the court stipulating a timeline for, my lord, the conclusion of the reference, and whether the parties could have by participation extended the timeline. Because, my lord, there are a couple of judgments which now says that, my lord, if today, my lord, the parties, my lord, of their own volition, for example, my lord, under 29A situation, my lord, 1 year, then 6 months, and then, my lord, the parties themselves say that very well we extend the time. Could the parties have done that without approaching the court? The law says now, my lord, it couldn't have. Similarly, my lord, when, my lord, the court fixes a time, it is only the court which can extend the time. My lord, we now know, my lord, in all these OTS and other matters, one-time settlement matters where the courts have held, that if today the parties have amongst themselves agreed to a time span, then the court cannot create a new contract for the parties by extending the timeline. However, if the court says that, say, make a payment within 1 month or within 60 days, in that case, the court retains the discretion to extend the time. So, my lord, one of the questions on which I shall be addressing your lordship is, my lord, this question as to whether the award passed, my lord, in this matter after the period stipulated by court in its order, my lord, is really an award which is without jurisdiction. My lord, that is one part of the matter. The second part is, my lord, here, my lord, as your lordship has been told that, my lord, The arbitrator was appointed by an order passed on 18th of February 2014. Well, the arguments in the matter were concluded in September 2018. Although, my lord, really 4 months was given, 4 years, my lord, was consumed in the reference. I, my lord, do not for once blame the arbitrator. It is always, my lord, the parties who are to blame in these matters. But, my lord, even after the arguments were completed in September 2018, the award came to be passed on 21st March 2022. So, my lord, the award, my lord, even after the final conclusion of arguments, my lord, came almost after, my lord, 4 years, close to 4 years. So, my lord, here, my lord, now we have judgments of the Supreme Court which says that, my lord, unexplained delay, my lord, is a factor, my lord, which will, my lord, call for interference with the award. But, my lord, also it says, the caveat is this, that the Supreme Court has also said that delay in itself will not be enough unless you can show that the long delay, my lord, between the conclusion of the, my lord, hearing of the matter and the delivery of the judgment is something that ultimately impacted, my lord, the findings that were raised. My lord, naturally, my lord, here also the Supreme Court has been now, my lord, very up and about and saying that, my lord, within what span of time judgments must be delivered, keeping in mind that, my lord, the matter is fresh in the judge's mind or, my lord, in the arbitrator's mind. So, my lord, the other fact is that that's a very recent, my lord, judgment of 2025 delivered by Justice Sanjay Kumar. I shall be citing that judgment for you. But, my lord, shown of all these, my lord, legalities, my lord, the question is, my lord, whether today the award, my lord, suffers from the usual, my lord, latches, my lord, on which, my lord, it can be challenged under the grounds available under Section 34. My lord, these are, my lord, the questions. Now, my lord, here, my lord, the contract was for, my lord, construction of a chimney. My lord, my lord, the applicant before your lordship, my lord, which was the respondent in the arbitration, had entered into a contract with Korba Power. My lord, Korba Power, my lord, gave it a project which involved, amongst other things, the erection of a chimney. My lord, the petitioner did not have expertise in erecting chimneys, so, my lord, it appointed a subcontractor. The subcontractor was the claimant in the arbitration proceedings. The subcontractor, my lord, represented that it had requisite expertise in the chimney. My lord, the matter could not be proceeded with due dispatch because, my lord, land was not made available, site was not available. My lord, there was escalation in costs. My lord, the claimant itself said that my costs are now escalated. I have to be paid more. So all these things ultimately, my lord, led to discussions between the parties. And here what is important is, my lord, the arbitrator himself holds that, my lord, the claimant was a nominated subcontractor. Now, my lord, when it's a nominated subcontractor, he really, my lord, establishes under the provisions of Section 194 of the Contract Act a privity with the principal, my lord, employer.
Yes.
Now, my lord, so therefore these are questions, my lord, which will be important. Now, my lord, ultimately, all these, my lord, discussions with regard to, my lord, time delay and escalated costs, my lord, brought about a situation where, my lord, ultimately, my lord, the contract was terminated in the sense that, my lord, there was an agreement to demobilize.
Yes.
My lord, parties have accepted that this amounted to a termination of the contract. Now, my lord, what my learned friends contend, and, my lord, what the tribunal has also, my lord, accepted, is that, my lord, the decision to demobilize the contract was not immediately communicated by the, my lord, respondent petitioner before your lordship to the claimant, and the claimant remained under the impression that, my lord, the contract is still subsisting. Now, my lord, what is not discussed in the award is, my lord, how, my lord, this impacted matters, because, my lord, today, if, my lord, my principal has said that you demobilize and take away all your men and equipment, my lord, then, my lord, naturally, my lord, further work at site was not possible. My lord, my subcontractor, then, my lord, I would be, my lord, completely insane to allow my subcontractor to go ahead and do the work. And, my lord, the subcontractor said I remained under the impression that the contract is subsisting. But, my lord, it does not say what work he did thereafter. And, my lord, the basis of the claim is a claim on account of, my lord, on account of running account bills which were raised, my lord, subsequently, my lord, without the work actually being done. Now, my lord, here the contract provided a scheduled or, my lord, phase-wise graded payment, my lord, system. My lord, advance, then some on mobilization, some on, my lord, drawings and designs. Now, my lord, without doing the entire drawings and designs, my lord, on the basis of, my lord, the scheduled progress of payments, my lord, a bill has been raised for drawings and designs. Now, my lord, these claims have been awarded without, my lord, any adjudication. My lord, what I'll have to do is, my lord, take your lordship, my lord, through the award. Well, it will take a little time, but I was just thinking, my lord, perhaps it will be, my lord, profitable for us to, my lord, prepare a kind of, my lord, a chart, my lord, on, my lord, what are the essential grounds and how, my lord, it finds reflection in the award. Otherwise, my lord, the award is a long award. It's a 71-page award. It will, my lord, take unnecessarily consume the court's time. But, my lord, here, if your lordship will, my lord, kindly see, my lord, one or two, my lord, aspects of the matter. Just for example, my lord, if your lordship sees, my lord, page 199.
199.
199. Well, this is, my lord, one of the running account bills on which a claim has been made. Well, if your lordship sees, well, this is the RA bill number 1. Now, my lord, this is a bill raised on the basis of, my lord, the graded payment schedule, 5% payment due of rupees 11 crores 7 lakhs on submission of design drawing as per your terms of payment. Now, my lord, the fact is that, my lord, the entire designs and drawings were not submitted. But, my lord, it is on this basis that the bill has been, my lord, raised, and this bill has been accepted for payment by the London Tribunal. Then, my lord, if your lordship sees, well, in fact, my lord, out of the 56, my lord, drawings, only 10 had been submitted. My lord, that is all on record. I shall show your lordship. Then, my lord, if your lordship sees the next, my lord, bill, my lord, RA bill number 2, well, that's at page 201. 15% payment due of 11 crores 7 lakhs on mobilization of manpower and plant as per your terms of payment. Now, with the greatest of respect, today, ultimately, in a contract of this situation where the contract is terminated, one has to come forward and establish what is the actual cost of mobilization for which a claim can be made. Well, it's simply saying that 15% payment due on account of mobilization without showing us to what is the mobilization, what has been made. Well, the question is whether this then amounts to awarding of because these are all claims for damages now, not claims on account of actual expenses incurred. But I understand that there's a supply contract where I have supplied a transformer, and I have made a bill or a payment in claimed a payment in respect of that transformer. That is for actual work done. Or there's a building to be constructed. I have constructed the first floor of the building. This is the graded payment, actual work done. But when you say that I am entitled to 15% of the entire cost of the building, without completing the work, then it's really essentially in the form of a claim for damage. If it is in the form of a claim for damage, the law now very clearly stipulates that the damage will have to be established and proved. Now, this is the bill which is again raised for 1 crore 71 lakh 69,404, and it is accepted without any proof of work actually done. Then so far as equipment is concerned, or I shall not trouble your lordship with that. May I straight away take your lordship to the award? The award starts at about page koto? We have given the award is in a separate volume.
Yeah, it is here.
Yes. Well, I think some of the pages were illegible, so we have prepared with your lordship's legal file a supplementary affidavit containing the award. One page, original award page.
No, I have the original award.
Original award. For what?
Not of award. No, but isn't this the original award?
No, my lord, that award is, my lord, I think there's no difficulty with the award. I think, my lord, what my learned friend says, I have not had a look. It says, my lord, some of the pages, my lord, in the brief, my lord, are not legible.
Yeah, the award is legible. In the brief, maybe it's. There's no problem with the award.
No, my lord, there's no problem with the award. Now, may I straight away take your lordship, my lord, to the first concluding portion of the award. Well, at first, your lordship will kindly see, my lord, what were the respective claims made by the parties. That your lordship will find at page 17 of the award. Well, outstanding amount due under bills submitted to the respondent. Well, that is for 2,71,71,868. Then extra item of work, designs and drawings. Then advance paid to vendors, suppliers, loss of profit at 10% on balance work, transport charges, demobilization charges, overhead charges, idle manpower, idle equipment, or rental of containers, storage charges of equipment, loss of goodwill, claims arising out of demands from vendors, loss of profit and idling charges. Payment for work done beyond what was included in claim 1, reinforcement work, interest, arbitration costs. And then there were counterclaims. Claim for refund of amount overpaid to the claimant, which was for a sum of 23 lakhs and odd. And the interest there on costs of arbitration. These were the claims that were made by the parties respectively. Now, if your lordship will now, please have a look at. I'll skip over the discussions for the time being. Well, at paragraph 85 of the award. I'm sorry, my lord. I'm sorry. Claim 1. Yes, my lord. Paragraph 40. I'm so sorry, my lord. Paragraph 40. This is my lord, the discussion on the claims. Lord, first, my lord, I think I should start from paragraph 30. My lord, 8. Well, this is what the tribunal holds. In such circumstances, I am unable to agree with the submissions of the respondent that the termination or rescission of the contract with the claimant was owing to the defaults and delays of the claimant or any fundamental or repudiatory breach of the claimant. Once it is held, as I have done, that the termination of the contract between the claimant and the respondent was for reasons which could not be attributed to the claimant, and that it was really the direct result of dissensions and irreconcilable differences between KWPCL and the respondent and their mutual decision to demobilize, which decision was in fact kept suppressed from the claimant for nearly 2 months, during which period the respondent continued to lead the claimant to believe in and rely on acts and act on its representations, both express and implicit, that the contract continued to be subsisting and valid, and the project was required to be completed with expedition, the claimant would become entitled to its claims for compensation arising out of loss and damage occasioned to it under several heads of the claims. Now, my lord, pausing here for a moment, your lordship will notice that, my lord, 2 things. The tribunal first holds that it was not on account of the claimant that the project was delayed. Number 2, my lord, it was not the claimant's, my lord, fault that the project had to be terminated. And number 3, my lord, it says that you kept the fact of termination of the contract suppressed from the claimant for almost 2 months. Now, my lord, there is, however, no reflection either in the pleadings or in the documents or in the word that, my lord, during these 2 months, my lord, the claimant had performed any extra item of work or incurred any extra, my lord, heads of expenditure. And, my lord, that is also not stated in the award, because it only says you kept it suppressed. You kept them under the impression that the contract is still subsisting. I do not know, my lord, how that would impact the claims at all. Then, my lord, the first question to be considered is whether the claimant is entitled to its claims on account of sums outstanding in its favor. The claimant has quantified the said claim to be rupees 2,71,71,868. According to the claimant, the respondent has failed to make payment under invoices raised by it. The claimant has disclosed bills being RA bill number 1, dated July 1, 2010 for rupees 55,35,000. RA bill number 2 dated 21st March 2011 for rupees 1 crore 66 lakhs 5,000. RA bill number 3 dated 20th July 2011 for 5 lakhs 28,500. Reinforcement bill number 1 dated 25th April 2011 for 4 lakhs 20,000. Reinforcement bill number 2 dated 20th July 2011 for 4 lakhs 20,000. Amount of the said bills along with service tax added thereto is a sum of 2 crore 63 lakhs 75,533.60. A sum of rupees 63 lakhs has been received by the claimant. This leaves an outstanding sum of 2 crore 75,533.60. Claimant has added interest thereon at the rate of 18% per annum on and from the date of the said bills until April 10, 2013. Based on the aforesaid calculation, the claim on account of outstanding bills is amounting to 2 crore 71 lakhs 71,868.60. This is with interest at 18%. Contract between the parties does not debar the claimant from claiming interest on account of delay in making payment of its bills. The bills which have been drawn and raised by the claimant on the basis of schedule in terms of which it was to receive phase-wise payments. According to the respondent, it has made overpayment to the extent of 23 lakhs 12,029. Claimant's first counterclaim with refund of alleged extra payment by the respondent. It is pertinent to note that the respondent had duly received each of the aforesaid bills mentioned above. Respondent did not contemporaneously dispute the veracity and correctness of the amounts claimed by the claimant under the aforesaid bills. Now, this is very important because your lordship will find that so far as this is concerned, it is not a matter of my denying the veracity of the bills. Now, the bills are raised in terms of phase-wise payments under the contract. The veracity of the bills would not be important. What is important is for them to prove that these amounts have in fact become due and payable for works done under the contract. Because when a contract is terminated, then the question is whether the payments, phase-wise payments, would still hold good. Just to illustrate what I am saying, today I agree that the total value I shall pay you to construct my house is 1 crore of rupees, and I shall pay you an advance of 10 lakhs of rupees and thereafter phase-wise graded payments. But if the contract is terminated, then the question is, if you receive more money for the work done only on the basis of the graded payment or the scheduled phase-wise payments under the contract, then you're really claiming money on account of loss and damages that you've suffered without the work actually being done, because you're not ultimately correlating it with the quantum of work really done. What the learned arbitrator has said that you have not contemporaneously disputed the bills, and hence they are entitled to the payment. With the greatest respect, there is an inherent fallacy in this decision, because what had been argued before the tribunal, I find from the notes that are available with me, is that these amounts had never become due and payable, although the contract stipulated a particular phase-wise rate of payment. So far as this is concerned, just pausing here for a moment before I come back to it, please see what the learned arbitrator has said with regard to the phase-wise payments. That's paragraph 15 of the award. I'll just take your lordship back a little just to demonstrate this point. That's at page 11 of the award at paragraph 15.
Yes.
There was some back and forth with regard to the terms of payment, but ultimately this is what the tribunal records. The respondent's response would appear from its letter dated such and such, wherein the following terms of payment would appear: 15% of the contract value on mobilization of manpower and plant, 5% of contract value on submission of design and drawing, 2.5% of contract value on completion of RCC foundation, 10% contract value on completion of slip form assembly, 10% of contract value on completion of RCC works up to such and such, and then it goes on. And then at the end of this table, your lordship will find, in other words, the respondent agreed that the payment allocated against internal painting work should be relocated, but the payment to be made on completion of RCC foundation, then 16. There have been subsequent correspondence between the parties making further modifications to diverse clauses of the work order. However, the payment terms ultimately stood finalized in the manner as mentioned in paragraph 15. Well, that is what the tribunal holds. So, it is a phase-wise payment. But, when the contract is interdicted or terminated, the question is, to what extent is a party entitled as of right to seek these phase-wise payments? Because, I understand that I am entitled to the value of the work actually done And well, then, well, if I say that because of the termination of the contract, which I say is wrongful or wrongful to me, I'm entitled to loss and damage, then I have to quantify the exact amount of loss and damage. Without the quantification, simplicity proceeding on the basis of the phase-wise payment, the question is whether this payment can at all be sought. Now, this is what was agreed between the parties. Then, coming back to paragraph 45 of the award, 44. This is what the tribunal holds. It is pertinent to note that the respondent had duly received each of the aforesaid bills mentioned above. The respondent did not contemporaneously dispute the veracity and correctness of the amounts claimed by the claimant under the aforesaid bills. Dispute raised much later is clearly an afterthought. Bills were raised between 1st July 2010 and 20th July 2011. In respect of RA Bill number 1, the respondent contends that the claimant would be entitled to only part payment for submission of RFC drawings, since the claimant did not supply all the drawings which were to be submitted by it in terms of the instructions of Mrs. Stoop. Stoop was the consultant appointed for the project. Again, in respect of RA Bill number 2, the respondent contends that the requisite mobilization was not done by the claimant. The aforesaid dispute raised by the respondent do not appear to be sustainable in the light of documents disclosed by the parties. The documents R23 and R31 relied on by the respondents are emails or letters which were issued after the bills relating to the relevant stage-wise payment had been received by the respondent. The letter dated September 3, 2011 from the respondent, being R23, acknowledges that RCC raft was completed on 24th June 2011. An email dated 22nd January 2013 from Stoop to the respondent records the submission dates of latest revision of designs and documents and drawings. Approval by Stoop is also confirmed by an email dated 18 January 2013 addressed by the respondent to Stoop. With regard to the two reinforcement bills of the claimant, the respondent acknowledges and admits an indebtedness to pay, albeit a lesser sum, than that claimed by the claimant on the basis of its purported measurement sheet, and as per the rate set out in the document marked as C58. In support of RA Bill number 1, the claimant has interiorly relied on several exhibits. In support of RA Bill number 2, the claimant has interiorly relied on exhibits. I do not find any good reason to disregard or ignore the contents of the aforementioned communications which record mobilization of manpower and plant as well as submission designs. Well, I pause here for a moment. So, what the learned arbitrator really does is says that the bills have been raised, contemporaneously bills have not been challenged, and I have, on the basis of documents exhibit, no reason to disregard the contents of the communications which record mobilization, submission of designs and drawings. There is no finding as to how many sets of designs and drawings or how many different designs and drawings were to be submitted, because our specific contention was 56 drawings were to be submitted.
Right.
There is no recording of the fact that how many were in fact submitted and is available from the records of the proceeding. We say only 10 were submitted. Well, there is no recording of the fact that as to what was the total cost of mobilization, because they have not mobilized the entire man and machinery for the entire duration of the contract at one go. This was really in the main nature of a mobilization at once. Well, there is no finding to that effect. Obviously, some amount of mobilization was done, but there is no attempt to quantify what is the amount of mobilization. 66 lakhs rupees was paid to them. That is a admitted fact. The question is, we say that on the basis of the stage-wise or graded payments agreed between the parties, we have in fact paid you more than what you have actually worked.
That is your counterclaim of
Yes, 23 odd lakhs. It's not a very major counterclaim, but we say we have overvoted. But what is very important is this, that ultimately your lordship sees, perhaps it's the passage of time, perhaps it's because of the obscurity of matters with regard in the passage of time, that there is no attempt to find out that, look, the respondent says that he was supposed to give 56.
Stoop is this consultant based out of Bombay?
Yes. Yes.
I used to represent them. Should I hear it or shouldn't I hear it?
I think there's no difficulty on that.
No difficulty.
No difficulty.
I just
No, your lordship has
recollected
expressed
that.
your lordship's mind. I think that is more than that is required, but we have no.
I just recollected that if it's the same, because
No, there's no difficulty. And Stoop is not one of the parties to the proceeding. It is a consultant which acted in the matter.
I remember he was client of mine when I was practicing. So that's why I just wanted to make it.
I'm sure, my lord, there will be several such instances, but my lord, unless there's a direct involvement, I don't think, my lord, the court should recuse. My lord, just to, my lord, highlight, my lord, initially, because we are just opening our arguments in the matter. My lord, here your lordship finds that, my lord, I shall point out from, my lord, the pleadings, and my lord, showing your lordship, my lord, the bird's eye glimpse of the award.
Right.
From the pleadings, your lordship will find that the specific case is that you have given only 10 drawings. The
On
contract,
what basis the award has been passed, granting damages?
my lord, your lordship will find that, my lord, here, the last 3 lines, I do not find any good reason to disregard or ignore the contents of the communication. So, my lord, the bills, which are not, my lord, bills for work done, my lord, are allowed, my lord, simply because they are the graded payments. Now, my lord, in a normally a works contract, your lordship finds that, my lord, I do a particular work, I raise a bill, that work is measured, the bill is accepted, approved, and, my lord, becomes due for payment. Then, my lord, the second bill, then the third bill. And, my lord, these bills have to be paid so that they provide, my lord, the finance to carry on with the work. But, my lord, here it is not such a case. Here it was a, my lord, phased payment or a graded payment that was agreed between the parties, that I shall pay you in phases the entire value that is agreed. It's a lump sum contract, but the contract is terminated, rightly or wrongly. A party is completely at liberty to say that the contract is wrongly terminated, I'm entitled to loss and damage, but then he has to come and quantify the extent of loss and damage. For, my lords, asking for payment on the basis of bills raised, in such a situation, my lord, it is not enough to say that I have raised a bill on the basis of graded payments. The party has to come and say that this is the work I've actually done, this is the expense I've actually incurred. Look, mobilization, you have paid me 100 rupees. I have actually, my lord, mobilized men and machinery to the extent of 95 rupees. These are the bills. Look, so far as drawings are concerned, you have to pay me 100 rupees. I've actually given you drawings worth 95 rupees. So this is the what is due to me. Well, that is not the situation here. And if your lordship sees, my lord, after, my lord, discussing the evidence, well, it's saying relied on exhibit such and such, ultimately, my lord, the main point is, my lord, really ignored or missed. My lord, ignored is perhaps too, my lord, harsher word. My lord, missed because, my lord, ultimately, the question that would have, my lord, fallen for consideration or ought to have fallen for consideration is, what were the total amount of drawings to be given under the contract? What was the total number of drawings given? What is the value that you're entitled to receive for this? What is the value that you've been paid? What is remaining outstanding? That discussion is absent. Mobilization, that is the amount that you're supposed to pay. How much have you spent on mobilization? Because, my lord, I have records of mobilization. I'm a contractor. Number of equipment I've hired. Number of equipment I've transported to the site. Number of, my lord, men I have, my lord, brought into the site. Their salary registers, their wages registers. None of that is, my lord, taken into account. And, my lord, without that, my lord, ultimately this claim is awarded in its entirety with interest at 18%. My lord, this is, my lord, what goes on. My lord, retention works, my lord, there are to an extent, my lord, we have certified. My lord, retention bills, I am not raising a dispute. RA bills, my lord, is what is in dispute. My lord, this is what your lordship will find, my lord, has happened throughout the length and breadth of the, my lord, award. My lord, similarly, if your lordship sees, my lord, this is the first claim. My lord, paragraph 46 onwards is, my lord, they're dealing with regard to the reinforcement bill. My lord, all in respect of the works of reinforcement mentioned in the aforesaid Reinforcement Bill 1 and Reinforcement Bill 2, separate work order was issued. The work was done under the principal contract and was an integral part thereof. The work orders were not in respect of independent, isolated, or unconnected work, and the claims of the claimant thereunder are certainly disputes that fall within the realm of the wide and comprehensive arbitration agreement between the parties. Work pertained to reinforcement steelworks for chimney raft as part of the same project and is an integral part of the primary contract between the parties. While work order may have been issued separately, the contract was one and the same. The preliminary objection raised by the respondent with regard to the arbitrability of the claims under the reinforcement bills have been rejected by me earlier on. The aforesaid reinforcement bills have been pending since April 2011 and July 2011, respectively, without the same being effectively controverted with regard to the contents thereof. The claimant, as per Reinforcement Bill number 1 for cutting and bending of reinforcement steel, And as per reinforcement bill number 2 for fixing and shifting of reinforcement steel, claimed payment of 350 metric tons. Part payment was made of a substantial part of these bills. The balance payment cannot be denied. I am unable to find any justification for disregarding and rejecting the claims thereunder based on the documents disclosed as R32. Well, pausing here for a moment. Well, let kindly see, documents have been disclosed. These have been marked as exhibits R32.
Yes.
The contents of R32 have not been proved before me. I am disinclined to rely upon such unverified tabulation, particularly when the respondent did not take any effort to prove the veracity of the contents thereof by evidence adduced by a person professing knowledge thereof. Moreover, C58 does not in any way scuttle the claimant's claims in this regard. Now, my lord, so far as C58 is concerned, my lord, this is a quantification of the actual amount of, my lord, work done and, my lord, amount expended. Now, my lord, I can understand that, my lord, I say that this is not the quantum of steel that you have used a lesser quantum of steel. And I've made payment of the substantial part of the reinforcement bills. Now, my lord, therefore, my lord, the question is that if you do not believe what I have said, well, there has to be, my lord, some corroborative proof to show as to what is the total quantum of steel that the claimant has in fact used, which is the, my lord, basis on which the reinforcement bills have been raised. Well, there is no, my lord, attempt to do that. And your lordship sees that it is, my lord, largely because of passage of time, my lord, that this has happened. Now, my lord, what the Supreme Court has said, well, in its very recent judgment, my lord, I don't want to trouble your lordship because I have an Indian Kanun copy of it. I shall, my lord, get a SCC online copy. My lord, it says that, my lord, ultimately, if you find that, my lord, there is an unexplained delay in delivering the award, and, my lord, here the delay is almost of 4 years. And if you find that that has in any manner impacted, my lord, the conclusions reached in the award, then that is ground for setting aside the award. My lord, may I, my lord, come back on another day? Because, my lord, I would like to have the judgments available so that.
When do you want?
My lord, anytime next week, my lord. Okay.
Take down.
My lord, my learned friend is requesting for a week after, because, my lord, he wants to prepare a chart and, my lord, make it easier for both me and the court to, my lord.
When do you want?
Okay, bolo.
Next to next week.
Date, bolo. To give me a date.
Give a date. I don't have a date. April 24th.
No, 21st. My lord, any day, my lord, your lordship may keep it anytime before, my lord, the 20th. My lord, oh, well, no, my lord, that week I'm in difficulty. 19, 20, 21st, Delhi.
21st?
So then, my lord, may I request your lordship to keep it, my lord, the week commencing, my lord, from the 27th January. My lord, we'll start and finish it.
So we'll have
I
it
think
on
27th is a
27th?
holiday.
27th?
26th is a holiday, 27th.
Third. Learned Senior Counsel, Mr. Saab. Keep it for, list it for further hearing. All the pleadings are complete here.
Well, only one thing, well, as I was saying, well, there are some documents in the, my lord, petition which are illegible. Well, we've, my lord, made a, my lord, better compilation of only those pages in a supplementary. Kindly, my lord, accept it on record. My lord, if necessary, we'll rely on it, or otherwise.
Copy is not served.
I'll give it to him. I can't, my lord.
We'll see that.
Yes.
In the course of the argument, we'll see if it is.
I'll keep it then, my lord.
Much obliged, my lord.
Grateful, man.
Commercial matter. You know what?
But this has come on my instance, my lord.
Yes.
Lord, by an order dated December 17, 2025,
Yes.
my lord was pleased to, my lord, condone the deal and directed us to furnish, my lord, our bank guarantee.
Right.
Lord, Pursuant to that, we have submitted the bank guarantee to the learned register original site. Now, the register original site is now insisting that the bank guarantee number to be there in the order. On 22nd, we have deposited the bank guarantee and submitted all requisite documents. On 24th of December, the learned register contacted us and told that the bank guarantee number has to be there in the order sheet. May I hand over the entire bunch of documents?
Call the registrar. Why does he need the bank guarantee number? Huh? Call the registrar. Inform him. Ask him to take it. I'll call the registrar.
No, working.
And the day when you had mentioned it, you didn't had a renewed bank guarantee with the number.
No, it was there in the application.
The first day only.
No.
It is there in the application.
It's there in the application.
Tell him to accept it. Not today. It has come on to be mentioned. Disposed of. There's nothing to be here. Ask him to do it. No order is required since the matter has already been disposed of. No order is required since the matter has already been disposed of. The matter has been taken up on mentioning. I'll speak with him. We'll keep it after 2 days. You not today. You'll keep it after 2 days. I'll speak. I'll get the registrar inside. Call the registrar inside. Not today. Not. What do you do?
My lord, I beg to appear on behalf of my lord. By mistake, my lord, the matter was filed in the non-commercial division, my lord. It ought to have been filed with the commercial division, my lord. We also informed the learned registrar for transferring and making necessary corrections in the cost title, my lord.
Yes.
So, my lord, if my lord may kindly passes an order for transfer and corrections in the only AP will be AP com, my lord.
No, this has to be with an application.
My lord, we have made an application, my lord. Before
To the registrar, right?
To the registrar, my
You have to make an application.
my lord, we will, my lord. Kindly
Application.
grant me 3 days time. Within 3 days, my lord, we will make an application.
This is the new motion, right?
My lord.
Not today.
Grateful, my lord.
I'm for the petition, lordship. This is a content application. First time appearing before your lordships.
Yes.
Lordship, this is the quantum application. Your lordship's order annexed at page 17. Your lordships directed the municipal authority to dispose of the representation made by the petitioner with consider and dispose of the petitioner's representation.
For the KMC lordship led by Mr. Gopal.
Yes.
Already hearing has been taken place, order to be passed, and then one inspection is required to be done in the meantime.
Whatever it is, you're in contempt.
No copy has been served, and in the meantime, copy may be served upon us.
Take down. The petitioner has preferred the present petition, alleging willful disobedience of the order passed by this court dated 18/9/2025 in WP number WPO 748 of 2024. Full stop. Learned counsel for the respondent seeks and is granted 4 weeks time to file compliance affidavit. List after 6 weeks.
And copy may be served.
Copy.
Lordship.
Respondent KMC. Respondent KMC. Calcutta.
Lordship, hearing now I am serving. Lordship, I am serving.
Copy of the petition has been handed over to the council for the
Grateful to you,
respondent.
Lordship.
Calcutta. Give your name and number.
Grateful, Lordship.
Your name and number for the receiver.
Great.
Hey, Gopal. Take her name and number in the receiver list. Oh, yes. Monthly list. Yes.
One portion of the monthly statute number 14.
14 and 15 are similar matters, Lordship. I'm appearing for the judgment debtor. We are opposing the application.
What
I
is the
believe
application?
the petitioners are not appearing. The application is for withdrawal of the sum that was deposited in the 36-2 proceedings. I'm opposing this because Lordship is aware that had the fixed deposit been continued, the interest that was accruing would have balanced off the awarded sum. Now I had in the
Here, nobody's here.
let it be in the month of February.
None of the petitioner listed in the monthly list of February.
Lordship is not dismissing it, my learned friend is. Very well, let it be.
16, 14, 15, same.
14 and 15 same. Great.
I don't dismiss matters like that.
I understand. नाम तो लिखे दीजिए शावर का नाम लिखे दो चल great.
16.
Lordship, I am for the petitioner. A settlement talk has been going on between the parties. I seek an adjournment, Lordship.
Learned counsel for the petitioner states that the amicable talks are underway. He seeks an adjournment. Let this matter be listed in the monthly list of February.
Much
And
obliged.
appears for the respondent.
I'm applying for the respondent.
Oh, settlement talks are on?
Yes,
All right, learned counsel for the parties state that they're exploring the possibility of an amicable settlement. Praise for an adjournment. Let this matter be listed in the monthly list of February.
Much obliged.
Lordship, I am for the respondent in this matter. Lordship, the petitioner has preferred a Section 11 application. The arbitrator has been appointed in this. By an order dated 9th December 2020, Honorable Justice Shampa Sarkar had appointed an arbitrator.
Appointed. None for the petitioner. Dismiss in default. Dismiss in default.
So, my lord.
Dismiss for default. Arbitrator already appointed, right?
Already appointed. It is infractuous, my lord.
So point. Let him file a Section 17.
Grateful, Lordship.
In Section 34, my lord, I am opposing.
Who's appearing?
Our affidavit is on record, my lord.
None for the petition. In the interest of justice, adverse orders are deferred. List in the monthly list of February.
Great.
I am behalf of the award holder respondent.
My lords, I am for the petitioner, my lords. My lords, I am being led by Mr. Onivan Ray. My lords is currently out of town and returning back on the 11th night. My lords, I am praying for a nod this week, my lords.
One thing may I submit, my lord. It's very old matter, 2018. Kindly fix up on any date, my lord.
Not this week.
My lord, kindly fix up on
It will
20.
come up, not this week.
Very well, madam.
Well, next week I have difficulties. Kindly after with my lord.
At the request of the parties, let this matter be listed on
20th, my lord.
20th January.
20th. I have deeply obliged, my lord.
Award is of which year?
Award is 2018, my lord.
It's not far. 2018 is nothing. But at the request of the parties, monthly list of February.
My lord, kindly, my lord.
No, 18 is nothing.
My lord,
If my lords can kindly keep it on
This
20, my
is
lords, we'll
mat-
argue it on the 20th itself, my lords.
my matter is pending, my lord, since 2012, my lord. Award passed on 2018, my lord. My lord, already, my lord, 7 years passed, my lord.
Pending since 2012 forward.
Arbitration start in the year 2012. Award passed on to 2018, my lord. They have paper and appeal, my lord, 2012, my lord. 2018. My matter is still pending, my lord, after lapse of 7 years, my lord. My lord, kindly 20th, my lord, kindly fix it. I'm deeply obliged. 20 তারিখ দিদি 20 তারিখ নামটা লিখে দেবো না দিচ্ছি
Lord, I'm for the respondent. Lord, I'm opposing, my lord, a section 34 application.
Nobody's here,
Award,
Mr. Banerjee.
Award is on, my lord, 17th July 2018.
Nobody's here. None for the petitioner. In the interest of justice, adverse orders are deferred. Monthly list February.
Sorry, my lord.
Monthly list of February.
Very well. Doesn't really, my lord, matter to. There's a security, my lord, under 36 which has been given. My lord, that is continuing anyway, my lord, in my favor.
Feb.
Very well, my lord, whatever, my lord. They have not been appearing, my lord. In fact, I would have pressed, my lord, for dismissal, but my lord.
Not the first time.
February, no,
They have not been appearing. Order should
I-
become.
Plus-
Gopal, order should become.
My lord, 19th August 2025 was the last. Support in November.
Just once they have not appeared.
Before that, my lord, I think
There are two options. Either I make it not today, or I keep it after 2 weeks, or I keep it in the monthly list. You tell me whatever you want. I mean, I can hear it.
Well, it's their application. Well, can you keep it then after 2 weeks or my lord, in February? My lord, whatever can be.
Let it-
But my lord, just kindly, my lord, is record no one appears. That
I've-
my lord is recorded.
I've recorded.
Great.
Next.
Yes. Identical, section 34.
Identical order.
No. Here, my lord, the. No, dismiss করাচ্ছি না। No.
I wanted to say my lord.
No, I'm not asking for dismissal. To anybody's benefit.
Mr. Mitra, what do you want?
No, what is to anybody's benefit, my lord? It'll be passed over, my lord, or tomorrow, but not today. Because Mr. Paritos Sinha is appearing for the, I think, Sinha company or Mr. Sinha.
He was here.
Because it's the West Bengal.
Not today.
How's
You
it?
call him?
Not today.
Not today. Not today.
My lord, 17, I missed your lordship. Please, my lord, it was directed to dismiss for default. My lord, kindly
I'll tell you,
Yes.
petitioner has already been appointed. Why do you want to maintain your section 9?
No, my lord, let it be a formal order. My lord, not dismiss for default, your lordship.
All right, not today. We
Mhm.
cut down that order. Item 17, not today.
Master.
But it will have similar fate tomorrow also.
No, tomorrow.
Because now you have to move section 17. Either you convert this into 17 or
My lord, tomorrow I will.
tomorrow.
No.
But similar fate. You have to inform the other side. Where's the other side?
I'll inform my lord. Sir, of course I'll inform.
Who's the other side?
My lord, Sina and company is appearing. My lord, I will inform them. My lord.
Where's Sina and company? Call them.
My lord.
You are appearing, Sina and company?
17.
17,
Seven.
not today.
My lord, arbitrator has been appointed in.
Not today. Let him come back tomorrow.
Well, so it's a formal order.
Let him come back tomorrow.
My lord, no issue.
I can recall the order. I can pass an order that you want to withdraw this petition.
Very well, my lord.
All right.
All right.
Learned counsel for the item 17 mein karo. Learned counsel for the petitioner seeks to withdraw the present application since the arbitral tribunal has already been constituted and the arbitrator has been appointed. He seeks and is granted liberty to move appropriate application before the arbitral tribunal. Liberty is granted. Matter is dismissed as withdrawn.
Much obliged, my lord.
Grateful, Lordship.
My lord, before my lord takes up the next matter, humble prayer, my lord, item 20, I will just run in, my lord, from the next court. My lord has recorded that none have appeared. I am for the petitioner. My lord will only make it not today or keep it in. My lord, I was running from that court to reach here. My lord, my advocate on record is also not here.
Mr. Mukhopadhyay always comes up with these,
My lord, I leave it at that. I have no objection.
I'm only
I have no
praying,
objection.
humble prayer, my lord, only. My lord will list it. My lord.
Then, my lord,
My lord will fix it for
Mukhopadhyay-
hearing whichever date, my lord.
when do you want?
Whichever date.
Both the parties are there.
Yes, my lord.
When do you want it?
Well, whichever date is convenient to my lord. I have no difficulty. Even next week, any day, my lord, we'll keep it. We'll argue the matter out, my lord. We're ready.
my lord, then, my lord, may I then, my lord, take, because in this matter I find, my lord, no affidavits have ever been directed also.
Records.
Because all this while, my lord,
You want to file an affidavit.
then, my lord, the allegations are not admitted. The records should be, my lord, my lord, to be produced, and then, my lord, we can do the
File a
matter.
joint
My
convenience
lord, we'll do
compilation.
Yes.
We'll do so.
Learned counsel for the parties seeks and are granted time to file a joint convenience compilation set
Well,
within a period of
My
4
lord,
weeks.
Yes, my lord. Yes, my
In a
lord.
period
4
of 4 weeks.
Yes.
List in the monthly list.
and, my lord, just one thing, my lord, since, my lord, I'm not filing an affidavit, allegations at least, my lord, are not
Yes.
admitted, my lord, so far as the,
34 what allegation?
my lord, here,
You only practice.
my lord,
You go everywhere. Where have you seen this practice of filing reply in 34?
no, there is, my lord. Calcutta, my lord, we have this practice of, my lord. I don't know why, my lord.
How can there be any allegation, admission or not admission?
My lord, if there's an application, one doesn't file an affidavit, points are taken, my lord, saying that you did not file an affidavit, therefore, all the allegation now, which is absurd, absolutely, with great respect, my lord, I submit, but that's the
My
argument,
lord
my
can
lord, which is
record
being-
that it's denied. I don't have any difficulty. My lord can
Just
record.
kindly, my lord, just for records, because, my lord, I don't know where, my lord, will go and say you chose not to file an affidavit.
My lord can record since no
I'm sorry, my
affidavit-
lord, I'm putting my lord through this trouble, but sometimes we face this.
What do you want me to record?
Just only saying, my lord, since no affidavits,
No affidavit have been recorded.
the allegations are not
has been
denied.
called for. None of the allegations are
That's all. I'm so.
Public.
I'm sorry for that, but I'm just, my lord, making it.
I'm
This is the
sorry
only
for being
practice.
late.
I mean, here only I've seen this practice.
My lord,
In 34.
we go absolutely. Sometimes 34, my lord. I've seen. In fact, I faced that, my lord, in my lord's in the Delhi High Court, where, my lord, the first day, the other side came and started arguing.
Absolutely.
Judge, say, please argue. What is it? And 1.5 hours matter was over.
Absolutely.
We were happy, my lord. We were
That's the
award
practice.
holders.
That's the practice.
We were award holders. So I think at the initial stage, if we will also come ready, my lord, decides to enter in it, then it's different. But possible that at the face of it, my lord, may not enter in it.
Correct.
So 4 weeks, my lord, we'll come back
We'll
after.
do so. Deeply obliged,
You'll
my
file a
lord.
compilation.
Well, jointly we'll
Jointly.
speak to the African.
Great.
Deeply obliged. my lord.
My lord, Apurna Banerjee is appearing on this matter. I'm praying for not today due to some personal
Item number
difficulty.
22.
Last time also, you told me that she's in some personal difficulty.
Item number 22, 23, same award, challenged by both the parties, my lord.
At the request of the proxy counsel so and so appears and states that the main arguing counsel is a personal difficulty. Let this matter be listed in the monthly list of March. So 22 and 23 both are same, huh? So in one you have challenge, and the other one they have challenge. इसमें ऐसे करना कि 23 you appear for Union of India, right, madam? Yes. 23 में proxy counsel for states that the main asking counsel personal difficulty. 23 में करना counsel for the respondent, proxy counsel for the respondent states that the main arguing counsel in personal difficulty, and then keep both the matters in March.
I am for the petitioner, my lord. In this case, my lord, the respondent number 1, Mr. Ashok Chandra, has expired. And on the last occasion, the respondents were directed to furnish the details of the legal aids. Now, it appears that they are unable to furnish the details of the legal aids of the deceased.
So, Lordship, by way of a letter, we've already
They have-
intimated to my learned senior. Lordship, we were supposed to, he's absolutely right when he says that we were supposed to furnish the details of the legal heirs. We've inquired with the family. Lordship, there's no legal heir that we are able to ascertain. We've taken instructions, Your Lordship, the other respondents, Your Lordship,
They say that he has a son, but he's not in. But the family is not in touch with the son, said son. This is the case, my lord. Now, whatever falls from lordship, we will
peculiar situation,
peculiar
Your Lordship.
situation.
It will fall from me. I mean,
But it takes paper. It's like
do a paper publication.
that is the only objection of option available in this case.
You add the name of the gentleman, whatever his name is, the son's name, and do a paper publication.
Lordship, perhaps, Lordship, that exercise my learned friend undertakes. Because, Your Lordship, they will have to change the cost title.
They have to change the cost
Yes,
title.
so they'll.
I will.
You have to add the legal heir.
But until unless we know whom
The
to
legal heir,
whom
they
to
have
name.
already given the name of the person, right? They are
Yes, the name of the person we furnished.
the
Name of the person is not being furnished. It is being said.
Respondent number 1. Our client,
Ashok Chandra has expired,
so
but his son.
His son, we do not know the name of his son also because the person in question, his wife has predeceased him, and there's no one else.
The family would provide the name. Name has to be
Your
given.
Lordship, my
Maybe they are not in
instructions are
touch.
again, Lordship, I'm submitting on instructions. Very peculiar situation. But there is no iota of information of the son which is available with the.
So how will he deal with it?
Lordship, that is the predicament. Your Lordship, if he's making a paper publication.
What paper publication will he do?
With the name of the deceased, his address and Your Lordship, very peculiar. I cannot quarry with this, Your Lordship. Very peculiar situation. Your Lordship, when my instructing advocate was telling me this, Your Lordship, the best case scenario I requested them was to make a letter to my learned senior.
You make a letter to the learned senior.
We've already made that.
They've
Your
already
Lordship.
furnished a
On
letter.
that basis, you do a publication in the newspaper that any legal heir of such and such person.
Which is
Very good.
If no,
Yes.
then we'll proceed against.
Then
Then
we'll
proceed with the other respondents.
Then we'll proceed.
That's in that case 1 month time it may be because from the date of publication he needs
Learned
to
counsel for the petitioner
appear.
seeks and is granted 4 weeks time to serve upon the legal heirs of the deceased respondent number 1. Six weeks.
Grateful.
Grateful.
My lord, I beg to appear on behalf of the petitioner, my lord.
Appear for the respondent.
My lord, my learned friend has raised the issue of maintainability on the ground of limitation in this matter, my lord. My lord, the award was
the ground of
On the ground of
limitation.
Lordship, this 34 application has been filed beyond the limitation period. Although the affirmation date in the petition shows that it has been affirmed within the limitation, but the same has been filed beyond the limitation. In fact, after 6 months of affirming the petition. This is the case status, Lordship. I had handed over it on the earlier last occasion also.
My lord, we have also filed it along with the representation which we have made to the learned registrar of the Honorable Court, my lord. May I submit, my lord?
what representation have you made?
My lord, may take the representation which is in the records of the Honorable Court.
Supplementary affidavit?
Supplementary affidavit, my lord. We have supplementary affidavit copy. No, my lord.
You have filed your reply?
No, my lord. We are on the maintainability point, Lordship. There was a direction upon them to file a supplementary affidavit where they were supposed to show that, show their bona fide that they tried to file it within limitation, but due to the department's fault, it could not be filed. But, my lord, if your Lordship kindly sees at page
Supplementary affidavit.
8 of the supplementary affidavit, Lordship. The supplementary affidavit dated 19th September 2025. Page 8 of the supplementary affidavit, Lordship, will find the learned registrar's report.
Page?
Page 8 of the supplementary affidavit, Lordship. This is the registrar's report, Lordship.
You have the report?
Yes, my lord. May I submit, my lord? My lord, this is not in dispute, my lord, that this award was passed on 5th of April. 5th of April, my lord. Assuming that the award we have received on the same date, my lord, on 4th of July.
April
2024.
For 2024, my lord.
Yes.
Assuming that it was received by us on the same date, my lord. It was presented for filing on 4th of July, my lord. The date on which was affirmed and presented for filing, my lord. Now, my lord, kindly takes that my lord has gone through the report, my lord.
Yes.
Now it says it was returned, my lord. Now, my lord, and says after 5 months. Now, my lord, kindly takes, my lord. Page 9, my lord. This is not the correct statement, my lord. Kindly take page 9, my lord. Upload date time, my lord. My lord will find 7th of October, my lord. My lord will get the date. 7th of October, my lord. Now, my lord, what point? Similar matter, my lord, indicating came up before the coordinate bench of our honorable court, my lord. Similar matter. For the purpose of invitation, what will be the period, my lord? Chapter 39A involving same chapter, my lord. Similar issues, my lord. Calcutta High Court judgment.
Even in that case, my lord, if the
Let me complete my. If you are keep on like this, I cannot make submissions. Kindly allow me to make my submission. Give me the Calcutta High Court judgment. My lord. I'm so sorry, my lord. Gujarat High Court, no? Which one? My lord, there are two judgments I will rely upon. One is Gujarat High Court, my lord. Calcutta High Court. My lord, before I may place Gujarat, my lord, let me place this coordinate bench judgment of this court, my lord. Sorry, my lord, there was some. This is, my lord, reported in 2022.
What does Ghoch mean? Dumb.
My lord.
What does Ghoch mean?
My lord, kind of mess, my lord. This is not the judgment. I am relying upon Justice Indira Banerjee's judgment.
What does Ghoch mean? What does Ghosh mean in Bengali?
Ghosh.
What did you call him?
My lord, I called him dumb, my lord. Seriously, fumbling around.
No, that's not fair.
No.
On any junior, suppose I do the same to you.
My lord, they should have.
No, this is not accepted by this.
Sorry, my lord. I really apologize.
Absolutely. You did it once, I kept quiet. This is the second time you're doing it. You first call him.
No, not in that
You
way.
call him Ghoch.
No,
Which is Ghochu.
No, not Ghochu, my lord. That does not indicate that. I told him he should be ready enough with the documents because we have.
Should be ready enough with the documents. Sir,
My
you
lord,
are the senior counsel.
my lord,
Why
I have.
are you dependent on the junior?
My lord, I have prepared the judgments, my lord.
You have prepared the judgment before
I have
you
put
come to
it
the
there, my lord.
court.
It is upon them to keep the judgment handy, my lord.
This kind of language in the courtroom
Sorry,
is
my lord.
not
I'm
accepted at all.
so sorry, my lord. My lord.
Absolutely, and especially for a member of the bar, whether he's
No,
junior or not.
No, I do not.
Any member of the bar, this kind of language is not accepted.
I'm so sorry.
Not in my court, at least.
Sorry, my lord. I'm so sorry, my lord. Due to
None of the lawyers are slaves to you or to anybody else.
No, my lord. I'm extremely
They're
sorry.
all independent professionals and to be respected.
My lord, I bow down to that,
It's
my lord.
very unfortunate that you use this kind of language. With your judgment. Very unfortunate.
I'm so sorry, my lord. I apologize, my lord. I'm so sorry, my lord. So sorry.
If I start doing the same thing with you, sir, you'll feel very bad about it.
I'm so sorry, my lord. I'm so sorry, my lord. Extremely sorry. I'm apologize, my lord. Unconditional apology, my lord. I should have kept myself cool, my lord.
He's younger member of the bar. It's your fault.
Sorry, my lord.
Every individual needs to be treated with great respect, and especially the juniors, and especially in my court.
I will keep that in mind, my lord. I will always bear that in mind, my lord.
Not today.
My lord,
Not today. Not today.
Grateful, my lord.
Don't do this again. I don't appreciate this. Respect all your juniors with respect. None of the younger members of the bar are your slaves. All the matters tomorrow. And be better prepared next time.